जजमेंट आपका सेकंड हाफ, इट इज अंडर करेक्शन। डेट हम फिक्स कर देते हैं जजमेंट का, जिससे सीएवी वगैरह नहीं हो तो ज़्यादा अच्छा है, और अपने मन में भी एक प्रेशर रहता है कि भाई इसको करना है। सीएवी हो जाने के बाद वो ठंडे बस्ते में चला जाता है। It will be pronounced by 4.
For final disposal, item 2, second appeal 118 out of 190.
What about the short notes on your behalf?
Yes, we'll have 5 minutes.
Where is that? Where is that? I'm seeing the short notes on behalf of respondent number 2 to 4. How about your?
Flag लगा हुआ है।
दिखाइए सर। Council should do one thing. Actually, I was busy with correcting the order which is fixed for judgment today. During the lunchtime, I will go through it, your both the submissions. And there is one matter fixed at 2:15. But I will take up your matter first because I have heard it substantially. So, give me some time at least till lunch.
Yes.
Right? Post lunch, 2:15, you are free?
Yes.
Item 3, second appeal 219 of 2022.
Where is the appellant?
Your leadership, I pray for a very short process. Very short.
The central question of law have been framed.
Mr. Gupta has come.
Has he come to the court?
Huh?
Has he come?
He's there. He's there.
Yes.
Just go.
Okay, you are for the respondents.
Yes.
They are seeking pass over. You are by 12. Okay? Or maybe by 12.
Item 4, first appeal 207 of 2023.
Not today. You have responded to additional evidence.
Yes, we've responded. We've filed a counter affidavit to the IA.
What is your response?
The opposition is that no grounds are there if the provisions of Order 41 Rule 27 are seen. It is not ordinarily permissible unless they show that they have either discovered it subsequently or it is with exercise of due diligence.
What is it they are seeking to rely on?
They are trying to adduce new evidence that the college has been established somewhere else, and that evidence they did not lead before the court below, and therefore the suit was dismissed on the ground that they
Was
have.
it supported by any foundational pleading?
It was it was supported with foundation, but there is no ground as to why this evidence was not brought before the trial court and why it is being moved at the appellate stage. Even though Order 41/27, though it permits additional evidence, it is negatively worded.
They
And
are questioning the location of the college.
No, they are saying they had gifted the property, the land, for opening a college with a condition in the agreement that if the college is not opened, then the gift will stand revoked automatically. This is what they mention. So they are relying upon section 126 of the Transfer of Property Act. It is a fact that the suit was ex parte, the college did not appear for whatever reasons, but still the suit was dismissed on the ground that they have failed to prove that the condition in 126 was fulfilled, and for want of evidence, the plaintiff's suit was dismissed.
Now
So-
they are wanted to see evidence to that effect.
Now they are wanting to introduce evidence, but if Order 41 Rule 27 is seen, it does not permit that you can use this provision to make up a lacuna at the trial stage.
And otherwise also the location of the colleges cannot be proved by mere documents.
And that too by a Google page document without any witness examining the veracity of the fact. Only producing a
they are
document.
not seeking to adduce any oral evidence.
They are not seeking to.
Additionally.
They are not seeking. It cannot be exhibited. It cannot be taken on record only by way of an affidavit in this court.
Where is your counsel? We will impose cause for adjournment. Adjournment without prior circulation is not permissible in this court. When do you want? I'll impose some cost, you just tell us when do you want. Any day means tomorrow. I don't know any other day. If not today, it's tomorrow. So you better choose your own date. Record आ गया है? It's a short matter, Anders.
It is a short matter. It is a very short matter. The IA has to be decided first.
No. It will not be decided. It will be taken up along with the main. We'll see what are the consequences.
In fact, the term itself is also, it is not, the section 126 says specified event. Here the term itself was vague, and therefore we are saying that the condition itself was so vague as to not be in a position to be enforced. Moreover, it is also
Is
will
there
of
any
the.
finding that the condition was not enforceable?
No, there is no finding, but if the condition is seen, because we are in first appeal,
That's right.
we
You
can
certainly assail it.
we can assail it, and I can assail it only on legal grounds because my hands are tied. I did not appear and plead evidence, so I can only argue on points of law as to whether it is a condition which can be enforced.
FA number 207 of 2023. Your name, please, madam. Alicia. Give it in writing, please. Counsel for the appellant on instruction of advocate on record, Mr. Ayush Aditya seeks adjournment. She submits that the counsel is not available today to argue this case. Counsel for the respondents is present. आपको कोई intimation था? The learned counsel, upon a query of this court, has submitted that he was also not intimated about the he was also not intimated by the counsel for the appellant that they would be seeking adjournment in this case. No advance notice seeking adjournment has been circulated. However, for the ends of justice, the matter is adjourned at the request of the counsel for the appellant and is directed to be posted on First of May. On 1st of May 2020. नहीं वेल होने से फोन नॉट वेल नहीं होगा. फोन करने का काम दिस वी विल नॉट एक्सेप्ट. एडवांस नोटिस देना, अदर साइड को इन्फॉर्म करना, ये दोनों एकदम मैंडेटरी. वन टेक थिंग्स फॉर दैट बिकॉज फर्स्ट अपील इज सच अ बोर्ड. एक बार शुरू हो जाएगा तो यू हैव टू फ्री योरसेल्फ फॉर फ्रॉम रेस्ट ऑफ द कोर्ट्स फॉर एटलीस्ट 1 hour. देखते हैं ना, छोटा सा 10 मिनट बहस की एक ऑर्डर हो, पास ओवर भी नहीं हो सकता. और चूँकि सबमिशंस कोर्ट में दिखाते हैं तो आप लोग कोर्ट छोड़ के जा भी नहीं सकते. और ये कोर्ट थोड़ा सा स्लो है, टेक्स इट्स ओन टाइम टू डिक्टेट. फर्स्ट मे को करेंगे. On 1st of May 2025, under the same heading, subject to payment of cost of rupees 5,000 for Advocates Clerk Association. The deposit of the cost, the receipt regarding deposit of the cost be filed by latest by 30th of April, failing which this appeal shall stand dismissed without prejudice.
Item 5, first
ऑर्डर को
appeal.
अपलोड कर दीजिएगा आज.
Item 5, first appeal 37 of 1024.
Yes,
Rainbow analysis is not.
rejected. कॉस्ट चाहिए आपको, प्रोग्रेसिव कॉस्ट लगेगा. आपको टाइम चाहिए.
First time that I find time. Today I remain busy in item number 3 that has been passed over. You already see. उसी में पढ़ने में रहा है. तो
आइटम नंबर 3
हाँ.
किनका है? मिस्टर राहुल का
हाँ.
आ गए. करना है आपको? चलिए ठीक है.
चलिए उसी में होगा. टाइम है. इसको मंडे
अभी नहीं चाहिए.
मंडे कर दीजिए.
आपको बहुत बिजी है आप.
ठीक सर, इसलिए थोड़ा सा दूसरी जगह कहते हैं. मंडे को कर दिया जाए. आई एम रेडी टू मंडे या ट्यूसडे ट्यूसडे.
क्या सब्सटेंशियल
मिलट
ये
फर्स्ट अपील है.
अच्छा, first
ओनली 1 अवार्ड चैलेंज किया है. 13 फाइंडिंग है कि इट इज ए कमर्शियल. इशू नंबर 1 मेरे फेवर में है. इशू नंबर 2 में कहते हैं कि चूंकि नो डॉक्यूमेंट हैज बीन फाइल्ड विद रिगार्ड टू रेट, देयरफॉर जो है उसको हम नहीं करेंगे. बस
नहीं आज ही
नहीं,
थोड़ा
इसको-
सुनेंगे.
आओ थोड़ा सा
अब सुन
हियरिंग
लिया आपका, हम समझ गए.
हियरिंग है थोड़ा सा. हम रेडी है. ट्यूसडे को कर दीजिए. दे आर आल्सो ट्यूसडे. आई एम नॉट.
अगले साल कर.
नहीं, ट्यूसडे को कर दिया जाए. ट्यूसडे को
अच्छा आपका जूनियर है, थोड़ा बुलाइए ना भाई. जरा
जूनियर
देखिए.
कर देंगे, भेज देंगे. ठीक.
देखिए कोई भी फर्स्ट अपील
Yes,
ऐसे
yes.
नहीं डिसाइड करते
Yes.
हैं. थोड़ा सा समझना होगा क्या मैटर है.
यस.
उसके बाद हमें चलिए.
ठीक.
आप अपने जूनियर को भेज दीजिए. इंट्यून ऑर्डर थोड़ा देखेंगे.
ठीक ठीक
ठीक है.
ठीक. मच.
Also, this item 3, second appeal 219 of 2022.
चलिए.
Judgment of reversal, Your Lordship. I was the original plaintiff. My suit was decreed and then it has been reversed by the appellant on an appeal filed by the respondent state. So
Appellant is the plaintiff.
yes. Although this is coming under the heading final disposal, but no substantial question of law has not yet been. So, therefore,
ऐसे कैसे
although
हो
it is under the heading final disposal, therefore I pointed out. Nothing else.
अरे ऐसे
So,
कैसे हो सकता है? Substantial question of
हाँ,
law
हाँ,
frame
हाँ,
नहीं
हाँ,
हुआ
है
है.
different. Substantial question of law
हाँ है तो.
हाँ, बना हुआ है ना.
हाँ. वही.
And then I'm missing.
इनको बैठी के एक ऑर्डर
On order number 10.
24 फरवरी 2025.
हाँ, order number 10.
इनको दीजिए ऑर्डर का प्रिंट निकाल के.
नहीं, नहीं,
I
एक
apologize.
सेकंड आपको प्रिंट निकाल के देते हैं.
नहीं, I
अब तो आप
apologize.
बहस कैसे करिएगा बिना उसको देखे.
I apologize for wrong statement made by you.
एक सेकंड.
अच्छा हम देख ले रहे हैं।
अभी अभी दे रहे, तुरंत दे रहे, एक प्रिंट निकालेंगे 24 फरवरी 2025। क्योंकि आपको बहुत सुन के किए थे, आप देखेंगे तो
Problem
आपको
is
याद आ
that,
जाएगा।
Your Lordship, no one records it here, and it is not there in my file. also.
Associate.
It is not there. The admission
Print भी
order
नहीं है।
should have been there in the file.
मिस्टर काउंसिल, आप इनके
No, he another associate of mine is assisting me.
In this case,
Yes.
बुलाई जरा, कौन है?
Rakesh.
बुलाई थोड़ा उनको हम ही समझाएंगे। अगली बार अगर वो खड़े हुए ना तो पूरा और जजमेंट
हम-
पढ़ाएंगे एकदम इन द हाई कोर्ट ऑफ झारखंड से लेकर। बुलाइए जो असिस्टिंग काउंसिल है इस केस में उन्हीं को रहना चाहिए ना। दे दिए प्रिंट
और
दिए।
हम भी इसी के लिए आजकल फाइल में एकदम नाम लिख देते हैं कि ये इसी को करना है, and he I asked him to start.
चलिए याद आया आपको?
Yes.
एक बार देख लीजिए, पढ़ लीजिए।
Yes.
Can you read it?
Whether the first appellate court has wrongly reversed the judgment in decree passed by the trial court by making out that urban namas were not in terms of section 72 of the Chotanagpur Tenancy Act, and whether the learned lower appellate court was right in holding that Exhibit 3 was conclusive proof of possession as per section 84(3) of the Chotanagpur Tenancy Act, and whether the learned lower appellate court was right in discarding Exhibit B and 1 by B and 1 by C on the ground that they were beyond pleading in view of provisions contained in Order 6, Rule 2 of the Code of Civil Procedure, and whether the reversal of judgment by the learned appellate court is without quitting the reasoning of the trial court, and whether the appellate court was right in reversing the judgment and decree passed by the trial court on the ground that the deity was not made. So, Your Lordship, I recollect now, all these questions are involved in the instant here. So, I'll start and then I'll pray that Your Lordship may.
No,
Defer it.
let's see. We will defer it. Don't worry about it. But let us see. You read the respective case of the
He
parties.
is Rakesh Kumar Singh.
आप हैं मिस्टर राकेश? ये फाइल आपको असाइन है? तो सब्सटेंशियल क्वेश्चन ऑफ लॉ का प्रिंट क्यों नहीं है फाइल में? अच्छा हुआ आपकी ट्रेनिंग मेरे साथ नहीं है। कैसे चलेगा? वकालत चलानी है ना अपनी। आप अपने लिए काम करते हैं, सीनियर के लिए नहीं काम करते हैं। आप इस
नहीं हम तो उनको
concept को
बोले थे
भूल
कि
जाइए।
यही स्टार्ट करेंगे, and better that he starts because he has read it.
आप पढ़े हैं?
Yes,
सब्सटेंशियल क्वेश्चन ऑफ लॉ भी पढ़े हैं?
no, that I am not.
तो फिर आप सेकंड अपील में क्या पढ़े? इनको थोड़ा सा फर्स्ट अपील सेकंड अपील का फर्क, हाउ दे आर आर्ग्यूइंग, थोड़ा सा इन लोगों को बताने की जरूरत है। इसके बिना नहीं होगा। चलिए जी।
He otherwise reads just to protect him otherwise.
आपका काम है उनको प्रोटेक्ट करना अपनी जगह।
No, Your Lordship, my case, which was originally before the trial court in the claim, that has been mentioned by the appellate court in para 2.
Okay, that is complete.
Become more or less, but
We read it from appellate court or trial court?
it would be better.
Okay.
We read the from
Okay.
the plaint itself. That would be better from the original
Okay.
plaint.
Let us see. Now, better.
I'm reading from para 1 because the property detail is mentioned in para 1 that the lands in plot numbers 202, 203 and so and
Just
so
is the
area.
plain name. Plain. वो written ना। इसमें plain। Exhibit 6. me just continue. तो अपीलांट सिविल अपील करते हैं इसके तो लिखना कि डॉक्यूमेंटेशंस भी लगता है हो सकता है नीचे ऑब्जेक्शन हाँ क्लेम बताइए हाँ बताइए
You know, para 1 itself I am reading because the property detail is mentioned in
Yes.
para 1 itself. That the lands in plot number so and so, area 4.86 acres at Moja, Bakaspura within PS Barwata is a tank commonly known as Purana Bang. That this tank was originally recorded as Whereabad Malik land in the last cadastral survey record of right, and Panchulal Sondi as Kevardar, and he was in possession of the tank in question. That the said Panchulal Dasondi made a spiritual gift of the tank to Sri Sri Shiv Thakur Ji, a Shiv Mandir situated at village Bakaspura on 17/1/1923 by executing a registered Arpanama being gift number so and so, and since then the produce of the tank was being used for the worship and management of the said Shiva Mandir. That after the death of Panchulal Dasondi, his another co-sharer, namely Vaikuntnath Dasondi, also made an Arpanama gift of his share in the said tank on 17/8/1954, being deed number 226 for the said Shiva Mandir, and appointed Srimati Surti Kirti Devi, mother of the plaintiff, as Shivayat of the said Mandir. That thus the mother of the plaintiff, namely Surti Devi, Kirti Devi, continued to possess the land, and she managed the affairs of the said Shiv Mandir out of the produce of the said tank. She used to rear fishes in the said tank through caveats, and by selling the fishes, she used to sell proceeds of the management of the Shiv Mandir. That after vesting of Jamindari interest, the name of Surti Kirti Devi was entered as Shivayat Raya of the said tank, and she used to pay rent to the state of Bihar and continued to possess the same for the said purpose. That after the death of Surti Kirti Devi, the plaintiff, being her son, is managing the affairs of the said Shiv Mandir at Moja Bakaspura, but he could not continue to pay rent of the said tank. That subsequently, the plaintiff came to know that the said tank is being settled by public auction through the District Fisheries Department, Dhanbad. Therefore, the plaintiff made an application in the court of learned LRDC, Dhanbad, to inquire into matters and to stop further auction of the said tank. And the learned LRDC, Dhanbad, called for the report from Circle Officer Govindpur. Thereafter, he rejected the application of the plaintiff by his order dated 25/6/2004. That the plaintiff preferred in appeal against the order of the LRDC, Dhanbad, dated 25/4/2004, in the court of learned additional collector, Dhanbad, which was registered as miscellaneous revenue appeal number 9 of 2004. The learned additional collector, Dhanbad, dismissed the appeal of the plaintiff by his order dated 25/4/2005 and observed that the tank cannot be settled through the plaintiff, as it has been given in charge of the fishery department. That the plaintiff is Shivayat of the said Shiv Mandir, and he continued as such till today. The tank, which is more fully described in schedule below, is a tank of the said Shiv Mandir, and it has never vested in the state government, and the provisions of BLR Act so and so. This tank remained the property of the Shiv Mandir and through registered deed of Arpan Nama. Therefore, at the time of vesting of Jamindari interest, this tank remained as Rayati tank of the Shiv Mandir, which cannot be settled to general public by auction, treating it to be a government share. Even if the tank mentioned in the schedule below is enlisted as government share in the share register of the defendant, then also it cannot be settled to general public by auction, as the entries in the share register is wrong and it should be deleted. That the defendant number 1 cannot transfer the right title interest of the tank in question through its fishery department for settling the tank to general public, as the tank in question has never vested with the defendant number 1, but as the tank was recorded under their Abad Malik Khatyan, therefore the defendant wrongly presumed that the tank in question was vested in the state government, that the tank in question has changed its nature and character from their Abad Malik land to that of Vayati tank, and therefore the defendants have got no right, title and interest over the tank mentioned in the schedule below, whereas the plaintiff, being Shabayat of the said Shiv Mandir, has got perfect right, title, interest and possession of the tank in question on behalf of the said religious deity. That as the revenue officer has not considered the fact that the land in question has been dedicated to religious deity, and therefore the plaintiff has been advised to file a suit. And then those statements are again repeated, that it is the tank in question is it belongs to the deity, and therefore whatever is being done is bad. And then para 16, section 80 notice was given,
That's right. It's
and
okay.
then the suit
We have
was,
got the.
yeah. Then the suit for declaration was filed.
You represented yourself as the Shebayat of the Shiv Mandir. Is it a heritable right?
Pardon?
Shebayat is a heritable right.
Shabayat is a,
Heritable right.
yes, it is heritable. But even otherwise, not the plaintiff cannot only claim the property to be her own or to be his own. If the property would not go to the his only, Shabayat is only a manager of the
That's right.
deity. He cannot claim vis-a-vis the deity, he cannot. So ultimately, if the deity cannot come to the court, it is the Shabayat who is acting as a manager of the deity.
Deity as a person is not supposed to be made party.
It is not necessary. Those
Because
judgments,
that is the one of the substantial.
yes,
Now satisfy us on that. The deity is not required to be made.
yes. This question earlier also it has arisen in other cases also, and that is
What is the finding of the learned trial court to this effect? And then we'll come. Any objection was raised that deity is not a party by the respondents in the written statement?
Your Lordship, he'll answer all these questions. It would be Your Lordship.
अब बताइए भी.
हाँ, इनको थोड़ा सा मौका तो ऐसे भी मिलना चाहिए.
Question was raised, Lordship, that deity has not been party, has not met in party in the suit, Lordship. However, the trial court has dealt with that.
Has framed an issue to that effect.
Yes, Lordship.
Where is the issue number? Let us see the issues of the trial court.
Yes.
Then we will see. बताइए. Where is that issue? Non-joinder of party?
Yes, Lordship. Non-joinder of the party.
Where is it? Trial court has not framed such an issue. No such issue was framed. Irrespective of the issue, is there any finding? Is there any finding irrespective of the issue? आप ऐसे साइलेंट नहीं रह सकते क्योंकि आपने क्वेश्चन ऑफ लॉ नहीं पढ़ा इसलिए आपको पता ही नहीं कि क्या क्या सवाल आपसे पूछ सकते और आपने इम्प्यूट जजमेंट भी नहीं पढ़ा They've gone through. तो आपने कैसे बोल दिया कि इशू था? You must have read it but not understood it.
Ladies, kindly come to page 37.
37 of the
Yes, similar
internal
appeal.
page.
Yes.
अपील में नहीं पहले ट्रायल को दोनों कोर्ट का फाइंडिंग देखना पड़ेगा ना.
If your
There is no
lordship
such
would
issue.
only नहीं, if your lordship would only pass it over for 1 hour.
ये तो
after
गलत
two
है ना.
cases-
अब भी 15-20 मिनट सुनने के बाद अब आप आपको पास ओवर
नहीं सिर्फ
और दूसरा पार्टी आएगा तो हम उसको कॉस्ट लगा देंगे.
नहीं हम ये
आप पढ़िए हम रेस्पोंडेंट से पूछते हैं
हाँ,
क्योंकि
ठीक।
कल यही इशू पे वो बहस
ठीक
करेंगे.
ठीक
चलिए बताइए.
वही जो कल हमने
वही कहानी है.
वही लावण्या देवी के सिस्टम ये
आप देख लीजिए आपको 10 मिनट लगेगा आज
ठीक
बताइए. Is there any issue regarding non-joinder of party by the trial court?
No,
There is no such issue. Let us see the
issue that has been framed by the learned trial court is internal page number 6 of the trial court judgment.
बड़ी issue बड़ी.
Firstly, I would like to place before your ladyship the case of the defendant. If your lordship will permit. Because
Case, sir.
case
They
of
have
the
placed-
case,
placed
they have placed their own case.
Okay, you place your case. पढ़िए.
I am reading from the judgment of the trial court.
Trial court का judgment.
हाँ, the trial court से और if your ladyship permit, appellate court में वही है. The defendants appeared and filed his WF in which it has been stated that present suit is not maintainable by law. The present suit is barred by the principle of section 4 of the Jharkhand Land Reforms Act. The defendant has further stated that present suit is barred by the principle of law of limitation, equation. The present suit is not maintainable according to the facts of the case. The suit property tank situated in village Partition, which is commonly known as Purana. It is further stated that tank is being settled by the fishery department every year and it is sufficient to show that property has got no possession of the tank, rather defendant is in possession of the tank. It is further stated that in para 1 to 7 of the tank, it is stated that statements made there are not correct. It is further stated that all the tenure rights in government tank vested in the state of Bihar after coming into force of Bihar Land Reforms Act. It is further stated that situation of the temple being the side of the being by the side of the tank. Therefore, the tank to be owned and possessed by the plaintiff is a cock and bull story, hatched up for usurping the government. In para 8 to 13 of the plan, it is stated that plaintiff has got no right, title, interest, and possession of the tank in question. And the story relating to maintenance of temple through the earning of the tank is a bottom story. It is further stated that all the statements made by the plaintiff relating to ownership of the tank is strongly denied by the defendant. In para 14 and 16 of the plaintiff, it is stated that the statements made therein are not correct. It is also stated that tank has no relationship with the temple. It is further stated that tank is a public tank and it is the property of the defendant and the title suit is liable to be dismissed. Now the issue. On the basis of pleading of the parties, the latter court will affirm the following issue to intervene in the case between the parties. If the statement formally is present for, if the suit barred under the provisions of verbal stoppage and efficiency, if the suit barred by law of limitation, if the suit barred under the principle of section 4 of the Bihar Land Reforms Act. Because suit tank is property of Siumandi. Okasura, through its urban nama, and the plaintiff is the Sevai of the debt. Whether the suit tank is vested in the state of Bihar, now Jharkhand, and entered as the government's land. Whether the plaintiff entitled a decree for permanent detention, restraining the defendants, their men, agents, and officers, and the staff from settling them by holding public auction or otherwise to whatever causes the plaintiff is entitled. Now, the findings of the learned trial court. The findings of the learned trial court starts from para 9 of the trial court judgment. And above it, regarding the use of the token that has been mentioned, the findings starts from para 9. The plaintiff has examined altogether 6 witnesses, including himself, which are namely himself as PW1, Locus, Lokmar Misra, PW2, Bhagirath Tasandhi, PW3, Sarveswar Prasad Verma, PW4 is Anant Dhiwa, PW5 is Balram Prasad Sharma, PW6 is Prem Naran Sharma. He has exhibited following documents on record to prove his case, which are namely Exhibit 1, Arpan Nama dated 28/1/1923. Exhibit 1 by A, Arpan Nama dated 17/8/54. Exhibit 1 by 4, Arpan Nama dated before 5/46. Exhibit 1 by C, Arpan Nama dated 24/1/30. Exhibit 2, carbon copy of notice under section 80 CPC dated 24/5/2008. Exhibit 3, CS of Khata number 55. Exhibit 4, original for M of rent assessment 56/57. Exhibit 5, postal register extracts 66126 dated 16/2005. Exhibit 6, CC of order dated 25/4/2005 in Miss Appeal number 9 of 04. And Exhibit 7, rent receipt number so and so. The defendant has examined sole witness, namely Umesh Chandra Prasad. The defendant has produced documentary evidence on behalf of the Exhibit A is the CC of original Khatiyans of original Khata number 91, and Exhibit B is the application for information. PW3 is Sarveswar Prasad Verma, who is a plaintiff. He is plaintiff in this case. He is Sevaik of Seva Mandir, situated in Bakaspura, Mauda. In para 2, he states that disputed land is situated in Mauda, Bakaspura, Khata number 55, plot number 202 and 202, in which pond is situated. This is clear term, pond is situated. The total Rakwa is 4.86 acres. It is also known as Purana Mall. In chief, he has stated. The pond is registered as Gairabad Mall. Its landlord was Panchulal Dasaundi. He was also the Kakar of this pond. In para 4 of this examination chief, he states that Panchulal Dasaundi established a Shiv Mandir in Bakaspura, Mauda. He surrendered a posted pond for incurring expenses of temple to the temple. I registered deed number 17/1/1923. Since then, disputed pond is in possession of temple. Through its survey. The income from pond is used of incurring expenditure of puja parts of temple. Vaikuntha Nath Dasaundi, Chunna Devya and Urmila Devi were Sevaik of the temple. Chunna Devya and Urmila Devi were residents. That is why the present point was possession of Vaikuntha Nath Dasaundi. He was Sevaik. Vaikuntha Nath Dasaundi was nephew of Panchulal Dasaundi. He also died. Vaikuntha Nath Dasaundi disputed registered surrender deed dated 17/8/1954 in favor of Surti Kirti Devi, wife of Chandi Prasad Sharma. Surti Kirti Devi was the mother of the plaintiff.
This surrender deed was executed executed in favor of the mother of the plaintiff. So he does not belong to the same family.
No.
He is from a different family.
It appears to be.
Wife of Chandi Prasad Sharma. Then how this Bakund the Sondi is related to this Surti Kirti Devi, the mother of the plaintiff?
Again, just I here, 9. Surti Kirti Devi has got from Vaikuntha Nath Dasaundi by way of deed.
By way of a surrender deed.
Surrendered.
What is surrender deed?
That is
Arpan Nama, that means dedicated to the God.
earlier there was also
just a moment. It is surrender deed in favor of Surti Kirti Devi, not in favor of the deed. This surrender deed or Arpan Nama is not in favor of the deed. It is in favor of Surti Kirti Devi, and you claim that she was appointed as Shivai.
Yes.
She is not from the family. She is not from the family.
She is the mother of the plaintiff.
Yes, but she herself, who claimed to be the Shivai, is not from the same family. She is from a different family of the
Claim based on the surrendered. After death of plaintiff in possession of the process fund, and he incurred expenditure of temple from income received from fund. He beneficiary on that fund after eradication of Jamindari. His mother Sultan Keti Devi was paying rent to the government as a year, and she was Sevai of the temple again. In para 9, he states that he came to know that plaintiff wanted to settle disputed fund by auction. Then he filed an application before the police Dhar Samahar Dhanbad, but he dismissed his application dated 25/6/3. He again filed an application before Upper Samahar Dhanbad. It was also dismissed. In para 10, he states that disputed fund never vested in the government. It was royalty property of Shiv Mandir. And therefore, government has no right and title over the disputed fund. It is not government fund. Therefore, there are no right for its in para 11. He states that he has filed dispute after giving notice under Section 80 CPC after 60 days. He had filed original Appannama dated 81/23, which he was obtained from his mother. It is an old 30 years. It is marked by Unit 1. He has filed Appannama dated 17/8/54, which he has obtained from his mother. It is 30 years old. It is marked by Unit 1/A. He has filed Appannama dated 4/5/46, which he has obtained from his mother, which is 30 years old. It is marked by Unit 1/3. Appannama dated 24/1/30. He is obtained from his mother.
Let us understand one thing. You see, these Arpannamas, there are 3 Arpannamas.
Four Appannama.
Four Arpannamas.
Four Appannama.
Right. So this is
And pleadings of only 2 Appannamas.
this is in connection with the same property. Arpannama is in connection with the same property, or it is in connection with different portions of property.
I've seen the Appannamas.
But pleading is of only 2
Not
Appannama.
very clearly, it does not
And
define the.
Appannama, there is no mentioning of plot
That
number.
is,
No mentioning of plot
I also could not, because
If this Arpannama was in continuity to the Arpannama executed in favor of mother of the plaintiff by Arpannama dated 17/8/54, then only it can be said to be from proper custody. Otherwise not.
But if there is
Then
handling
only section 90 will come into operation. Otherwise it will not. So I just wanted to know whether the Arpannama is in connection with the same property. But you say that there is no clear description of the property in the Arpannama.
Because, Your Lordship, we have to also understand as to what was the situation in 1922. Whether exact detail or.
This Arpannama of 1954, does it refer to the earlier Arpannamas? This is exhibit number
There's no.
1/8.
This.
There is a- Next.
I could not find that exactly it is how it is all these 4 are how they are connected with each other.
Anyways, we shall see the documents. Now let us continue with the
yes. Perhaps plot number has not been mentioned. In cross examination, he states that he filed this case for bond. The old khata number is 55 there khata. A hard survey was conducted of disputed land, and in that survey also disputed is entered as Gairabad khata. In hard survey it has also been entered. This witness has stated. The plot number of bond is 202 and 203. He cannot state exact raqba of both the plots. He cannot tell boundary of plot number 202. The plaintiff himself has stated, but he cannot. In para 21, he states that Shiv Mandir situated adjacent to pond was not constructed before him. On the basis of hearsay, he is stating that Shiv Mandir was constructed by landlord. He has not seen any documentary paper regarding construction of Shiv Mandir by landlord. In para 22, he states that in the disputed pond, local residents take bath. They do Murti Visarjan during Durga Puja, Kali Puja, and Saraswati Puja. In para 23, he states that in the Shiv Mandir, local residents offer Puja Arjan. In para 24, he states that on Shiv Mandir, villagers offer milk, water, and other things. He never stopped worshippers from offering anything to Lord. People can come there for Puja whole year. In para 25, he states that plot number of disputed temple and pond are different. Your ladyship, the plaintiff himself has stated. In internal page 11 of the trial court judgment, after 4 lines, Internal
Yes.
page 11.
Yes. He does not know.
In para 25, it states that plot number of disputed temple and pond are different. Pond are different. Temple and plot number of temple and pond are different. I here in dispute, here the subject matter is pond.
But here it has to be read with the next line also.
Yes, पढ़ेंगे हम क्यों नहीं पढ़ेंगे? He does not remember plot number of temple, he plot number of
थोड़ा सा ऊपर से पढ़िए.
अच्छा ऊपर.
He never stopped worshippers from offering
Anything to Lord.
In para 25.
People come there for puja whole year. In para 25, he states that plot number of disputed temple and pond are different. He does not remember plot number of temple. The plot number of pond is 202 and 203. In para 26, he states that boundary of pond is in plot number 202. Surti Kirti is paternal cousin of कौन है अलग है श्रुति कृति पैटर्नल cousin of Vaikuntanath Swami. In para 28 he states that disputed pond is settled by government. This witness has admitted is settled by government. In para 29 he states that in column 12 and 30 Arpan Nama were not disputed before him, but he has personal knowledge about it. All Arpan Namas are related to temple and pond. All Arpan Namas are disputed by different persons, but they are disputed in favor of Shruti Kirti. In para 30, he states that his mother died before 15 years. Her age was 40 to 45 years at the time of death. In para 31, he states that he has filed an application before LRDC. The LRDC has inquired about their land from Vicharika on the basis of his inspection report, dismissed their application. They went for appeal against the order of LRDC, which was also dismissed. They have filed the case in the court of LRDC. He cannot give any statement regarding Arpan Nama mentioned in column number 11 and 30. That is why he cannot give any statement regarding it. In para 35.4, he denied the suggestion of defense that they have filed false case for grabbing government land. He denied that disputed land is the property of government. Now the PW1 is Lord Kumar Misra. He is resident of village Asamani. He is Barbada. He aged about 70 years. He knows plenty as well as his mother. He knows disputed pond also, which is situated in village Bakaspura, Khata number 55 and plot number 202 and 203. His total area is 4.86. He also known as Purana Band. He knows about the pond since his child. Surti Kirti was in possession of pond. He was managing Shiv Mandir from the income derived by doing fishing this way. Shiv Mandir was established by Panchu Swami. He had surrendered his pond to Shiv Mandir in the year 1923 for incurring expenses of temple. After him, nephew Vaikuntanath Swami took over. Vaikuntanath Swami was issued. He disputed surrender deed in favor of Surti Kirti Devi in the year 1954. After Surti Kirti Devi, plaintiff took over. In para 7, he states that plaintiff is survived from the temple. In para 6, he states that from some period, the forced pond is being auctioned by government by stating it as a government pond. It is not a government pond, it is a property of forced suit. His cross examination, he states that he has seen old Khatiyan of that land in possession of mother of plaintiff. Now it is plaintiff. In para 12, he states that old Khatiyan of disputed land and he is registered as Jharkhand. In that survey, Panchunatha Swami is mentioned. He knows that by landlord, they use disputed pond for washing purposes. Apart from this, it is used during Chhat Puja, Kali Puja, etc. Para 15, he states that it is used by common people. In para 16, he states that disputed pond is situated about 200-300 feet from Shiv Mandir. It has also come. This witness has also stated that disputed pond is situated about 200 and 300 feet away from Shiv Mandir.
And these witnesses are saying that it was being used by general public. Public purpose का use बता रहे, common public use to use.
Now this honorable court has to see what relief has been sought.
अब देखते हैं इसका finding ultimately क्या दिया.
हाँ finding है.
Yeah,
पहले firstly come.
आप सीधे finding में आइए.
Degree.
हाँ. नहीं आप finding में आइए.
हाँ finding आते हैं. Degree क्या इन्होंने मांगा है और relief क्या sought किया.
हम लोग देख लिए, वो तो हम लोग देख लिए.
इन्होंने recovery of possession भी अपने के लिए मांगा है. सिर्फ declaration का नहीं. आज हम finding करा.
Page 18.
Page 18. Issues. Issues involved in the suit as to whether after dedication of issue starts from.
So summing up all the evidence.
Issue starts from 12, 14. This is there.
आप आइए ना पेज नंबर 19 में
19. हाँ ठीक है
19 में लास्ट में आइए तो
Law-
summing
law-
up all the evidences oral
law-
and document
law points.
नहीं so
Law points
लंबी
ऊपर
उसके
हाँ, so summing of all the evidences, both oral and written, stated that tank is a tank belong to Lord Shiva for the maintenance and performing offering puja to Lord Shiva out of usufruct of the
इस पूरे
tank.
डिस्कशन में बिहार लैंड रिफॉर्म्स एक्ट का जिक्र कहाँ है?
आगे आया है
मतलब ये तो फाइंडिंग यहाँ रिकॉर्ड कर दिया
नहीं
आगे
यहाँ
कहाँ है?
आगे आया है इसमें आया है पहला
शुरू
पढ़ी
में आया अपनी जगह है लेकिन ये जो बोथ ओरल एंड डॉक्यूमेंट
हाँ, तो नहीं discuss किया।
इज अ रैयती टैंक बिलोंगिंग
हाँ
टू
नहीं
लॉर्ड
उन्होंने
शिवा
डिस्कस किया उन्होंने आगे पैरा 14 में इन्होंने
नहीं
किया
एक सेकंड जस्ट they say it is a rayati tank belonging to Lord Shiva but the surrender but that Arpanama of 1954 is in favor of the mother of the land, not in favor of shifting. Even if we assume that there is continuity of one Arpanama, one after another, that Arpanama is not in favor of the and initially Arpanama was in favor of the temple and then the Shivayat of the temple executed another Arpanama in favor of the mother of the land. ठीक है?
नहीं, उसमें क्लैरिटी नहीं
है ना क्लैरिटी क्योंकि जितने भी अर्पणनामा का जिक्र है that is in favor of the temple except this
54
हाँ और इसका बैक टू बैक जो डीड है दैट इज इन फेवर ऑफ द टेम्पल आगे आगे और ये यहाँ पर आने तक ये जो रैयती टैंक बोल रही हैं कि लॉर्ड शिवा का कम से कम 54 का डीड से तो नहीं बोल पाइएगा
हाँ
एटलीस्ट 54 का डीड से तो नहीं बोल पाइएगा बिकॉज 54 का डीड इज इन फेवर ऑफ द मदर ऑफ द
claim of the plaintiff based on it
So this finding that the tank belongs to Lord Shiva is not right. Even as per your case, just an observation for you to respond. Section 4,
law points argued by the plaintiff are thereafter the findings regarding it has been referred dedicated property based in the idol and juristic person that has been discussed.
ये देखिए bottom में आ जाइए ये in the present case
In the present case,
अर्पणनामा सब कुछ जिक्र है
being number 76 dated 17/1/1981, number 226 dated 17/1/1981 by 3973 dated 4/5/1956 AB, 165 dated 24/1/1930 are registered one and as such are after vesting laws became real and capable of law holding property in the same way as natural law. Meaning by the same of it. Now, the argument on behalf of the defendants that it starts from para.
ये उसके नीचे भी पढ़िए in a recent judgment
In recent rulings of our own High Court reported in 2018. In our recent ruling of our own High Court reported in 2018, volume 3, page 72, wherein Honorable Mr. Justice so held that Sarat settlement of the water tank of petitioner in favor of private respondent, once order passed by competent civil court holding the interest of the petitioner over the said tank, merely due to the fact that said tank is regarded as thereof does not ipso facto confer right on the respondent to settle the same through any other depriving petitioner from enjoying rayati rights.
ये मंगाई जाए 2018 का वॉल्यूम 3 जेल 370
Further,
ये रिट में ऑर्डर होगा
further arguments start our
18 का 3 जेल गया 370 ठीक
argument on behalf of defendants. Defendants have stated in their argument that plaintiff has no right at interest over the suit land. He is telling concocted story. The tank is being settled by the fishery department every year. That is sufficient to show that plaintiff has
based on our
no possession of this tank. Whether the defendant is in possession of the tank, it is further stated that all the tenuous rights in government tank vested in the state of Bihar after coming into force of Bihar Land Reform Act. The tank has no relationship with the temple. It is further ruled that the tank is a public tank, which is property of the defendant, hence title suit is liable to be dismissed. Now the issue starts and finding paragraph 14. Now we will decide the issue framed in this case on the basis of entire materials available on record. First we will discuss issue number 4. Is the suit barred under the principle of section 4 of the Bihar Land Reforms Act? Section 4 of the Bihar Land Reforms Act states that section 4 consequences of the vesting of an estate or tenure of the estate. Notwithstanding,
He has only quoted all
हाँ,
the.
provisions है, पूरा provisions है quoted. Yesterday I have also written this. Provisions, entire provisions have been quoted. Start.
Page 26.
26 will find referring section 34 regarding bar of the suit. The trial court has stated from discussion and provision of Bihar Land Reforms Act, the Bihar Land Reforms Rules, it is clear that present suit is not barred under section 4 of the Bihar Land Reforms Act. The present suit is not brought in respect of any injury or omission from a compensation assessment roll or in respect of any order passed under chapter 2 and 2(6) or concerning any matter which is or has been already been subject to any application made or proceeding taken under the said chapter. Accordingly, this issue is decided in favor of the plaintiff. Decided the issue in favor of the plaintiff. Next issue starts from 15. Issue number 5. Whether the suit tank is property of Shiva Mandir, Bakaspura through its Arpannama and plaintiff is its Sevait authority. The plaintiff has filed various registered Arpannama which are included on record. They are as follows. A reference है सभी exhibit का. The exhibit 1 was issued in the year 1923 by Panchu Lal Prasoni, in which he surrendered all his property which is in his possession in favor of Lord Shiva and appointed himself during his lifetime and after his death his brother son Vaikund Nath Gandhi as Sevai. This is the exhibit 1 by C. Arpannama dated Arpannama 165 dated 24/1/93. It was issued by Panchu Lal Prasoni. This Arpannama he has appointed Vaikund Nath Gandhi as Sevai for his suit. In the schedule of this Arpannama, details of property possessed by Panchu Lal Prasoni is the exhibit 1 by the Arpannama number 397 P3 dated 4/5/1956. By this Arpannama it was issued by Vaikund Nath Gandhi in favor of Lord Shiva, the Bakaspura and appointed Chunna Devi and Sevai during her lifetime. And after her death, his cousin Suddhi Devi. The exhibit 1 by A is a deed number 226 dated 17/8/1954. Issued by Vaikund Nath Gandhi in favor of Suddhi Devi. It is pertinent to mention that Vaikund Nath Gandhi has surrendered his share property in favor of Lord Shiva, Bakaspura and appointed Suddhi Devi as Sevai. He had no legal heirs. Suddhi Devi was his cousin. All the Arpannama exhibited and produced by the plaintiff are registered. The exhibit so and so are 30 years old document and are produced from public. The presumption of genuineness in the paper which is not debatable by the defendant. The defendants have filed CC or legal khatiyan in which alleged bond and respondee are mentioned as Anwar Bihar Sarkar. They also filed details of Hal Khazra and their corresponding Sabik Khata and Sabik Khazra which is marked as exhibit B. Old का भी और उसका भी corresponding हम लोगों ने फाइल किया है in order to show उसी से बना हुआ है. The defendant wanted to establish that suit land is registered in the name of Anwar Bihar Sarkar and the plaintiff has filed CS khatiyan corresponding to khata number 55 in which the name of Rayyat is mentioned as Gharabad Malik and Panchu Lal Prasoni as a Khewardar. It is admitted fact that it is found in Purana Band is registered in the name of Gharabad Malik Bihar Sarkar and thereafter Jharkhand Sarkar. The plaintiff is claiming possession and the right of settlement of Purana Band on the basis of possession and possession of equity citizen. The plaintiff has examined altogether 6 witnesses out of which PW1 to 4 has supported possession of plaintiff through various acts of possession. They are doing fishery of Purana Band by leasing it to Kewat and were managing expensive temple of Lord Shiva. The PW4 was doing fishery in Purana Band and earlier his father was doing so. It is admitted fact the government has now settled Purana Band in favor of independent contractor but during Johnson PW3 plaintiff has stated their process from only still in possession. The plaintiff has filed ruling of Honorable High Court of Jharkhand Ranchi in WPC number 2061 of 2016 Aditya Kumar Singh of the State of Jharkhand to Principal Secretary Land Development. In this WPC the court has held once an order has passed by the competent state court holding the interest of the prisoner of the said land merely due to the fact that the state recording the Gharabad Malik does not ipso facto confers the right upon the responding to settle the same to any person. I think it is not from inclined with it. The suit plan was recorded as Gharabad Malik in the last research survey and record of rights Panchu Lal Prasoni was as Khewardar. The plaintiff has filed in court in which the name of the mother is mentioned as Jean and was fixed pursuit after undertaking proceeding under the land from his mother was paying to the government of that. The plaintiff has proved through documentary evidence that his predecessor had surrendered, settled, gifted suit and favor Lord Shiva and appointed him as predecessor as Shiva with various Arpanama, which are internal. Lord Shiva is a legal person in the eye of law and he is capable of holding property on the basis of I decide the issue of property. Finding Lord Shiva is a legal person in the eye of law and capable of holding property and decides the issue. Holding this. Now, issue number 6, important. Whether the suit land tank is listed in the state of Bihar, now Jharkhand and entered as government surrender, the plaintiff is claiming his right over the suit on the basis of Arpanama filed by him. According to his pleading, Panchula Dasandi, who is primarily is suited of this case, was recorded Khabarda in record of filed CCS Khatyan. The defendant has not filed any notification, register or Salah register or any order by the person found by this auction by the plaintiff challenging the auction itself and the fund was in possession and mother was paying rent. It is admitted by deed that the deposit fund was auctioned in the year 2004-5. Deposit fund is registered in Sarat under Fishery Department in the year 1992, but have not filed any documentary evidence on their behalf. The defendant has filed certified copy of CS Khatyan application for information regarding Hal and Sabi Khata of an impugned plots. It is admitted that the disputed fund was registered as Ghairabad Malik, so it did not include. On the basis of oral and documentary evidence, I decide that suit fund is registered as Ghairabad Malik. It is admitted by the plaintiff himself that it is entered in government's rather. It is decided said fund is vested in the state of Bihar. This is the finding. And said fund is vested in the state, now Jharkhand and entered as government Sarats. This is the issue has been decided.
It has been decided that it is a government land.
Government land. But despite that, the suit has been decreed. Despite that,
The suit was not decreed.
suit was decreed.
Yes, suit was decreed in
Decreed.
spite of the fact that
Ah.
it was declared to be a government land.
Decreed. This is the important. And further,
You were the appellate.
and
What happened before the appellate?
appellate court. And further, the restraining order has been passed by your permanent agency in para 17.
Where is the finding of the appellate on
Appellate,
with regard to
appellate,
vesting?
yes. Appellate court had formulated the points for determination. In appellate court, some documents have been marked on behalf of the defendants as an additional evidence.
That was allowed.
That was allowed. It appears.
Which
No,
documents?
Correct.
He had rejected it.
No, correct.
Your Lordship may see page
Appellant का नहीं हुआ है. On the other hand, defendants have examined.
page 8 internal.
It is
Turning page 8.
नहीं आता हुआ है.
Keeping in view of the aforesaid provision of CPC as well as considering the date of order of circular of the aforesaid document which the appellant wants to bring on record, I find that the petition on behalf cannot be allowed and accordingly the
Fit
same.
to be rejected.
ऊपर में पर है जो on the other hand appellant defense examined only one witness deal.
But then also I was the plaintiff.
अच्छा ठीक है. On the other hand, appellant defense examined only one witness deal movement and have brought the certified copy of Khatyan original survey khata number 91 and an application is further which bar limit A&B respectively in the court below. During appellate stage, letter number so and so, including the list of tanks transferred to Fishery Department, letter number list of tanks settled for the Samiti for the year so and so, the list of
इससे
tanks.
कोई मतलब नहीं है. इसका
हाँ
कोई
मतलब
relevance
which have been marked as exhibit C by 1, C by 2, respectively as additional evidence by the learned principal district. Why do these are these?
This is primarily referring to the various options.
हाँ मैंने
I
ये
was
लागू
the
हुआ.
plaintiff, I was required to prove my case.
हाँ ठीक है. exhibit C by 1, C by 2 क्योंकि वहाँ
Makes
तो
no
ट्रैप कोर्ट में नहीं था. यहाँ पर
We
है.
have, there is no such question of law.
हाँ अब ये findings पे देखा जाएगा findings. ये
आपका the point of determination.
हाँ वही दिखा. Points for determination क्या बनेगा?
Further hearing, your Lordship
Paragraph
may,
30.
your Lordship, further hearing may be taken up on.
Paragraph 30. Paragraph 30.
That
Whether the suit tank is the property of Shiv Mandir Bhagaspura through its Apannama, and plaintiff respondent is the survivor of the deity, whether suit tank is vested in the state of Bihar, now Jharkhand, and entered as government Sara, and the plaintiff respondent is entitled a decree for permanent detention, restraining the defendants, their men, agent, officers, and staff from settling the tank by holding public auction or otherwise. Findings of this from the result of the judgment of the lower
दोबारा एविडेंस मत करिए,
evidence है.
दोबारा ओरल एविडेंस मत
हाँ,
करिए, आप सीधे फाइंडिंग
oral evidence को ही लिखी हुआ है.
पैरा 15 में पढ़िए.
Paragraph 15. After going through the entire evidence, either oral and documentary evidence, and documentary adduced on behalf of the party, I find that apart from the procedural evidence, the plaintiff has brought some documents which have been marked as exhibits such
ये
and such.
एग्जिबिट्स हो गया नीचे,
Exhibits पूरा है.
एज पर सेक्शन 4A.
हाँ, फिर उसके बाद
नीचे
I further find नीचे उसके बाद exhibit के बाद ये
ये तो
आया
डिफेंडेंट का एग्जिबिट्स है.
as per section 4A. इसमें डील किया हुआ जो इटैलिक जो बोल्ड में.
हाँ,
As per section 4A of the Bihar Land Falls Act 1950, such state or tenure including the interest of the proprietor or tenure holder in any building or part of building comprised in such state or tenure and used primarily as office or kachari for the collection of rent of such state or tenure and his interest in trees, forest, fisheries, jalkar, hart, bazaar, mela and ferry and all other society interests, as also his interest in all subsoil including any right in mines and minerals whether discovered or undiscovered or whether being worked or not, inclusive of such right of a leasing of mines and minerals comprised in such state or tenure other than interest of rayat or
This is important. So if it is other than the interest of rayat or
तो जजमेंट दिखाइए.
हम दिखा
देवने इनको तो पता ही होगा लेकिन
इनको होगा लावण्य देवी किसी को अभी
लावण्या देवी
but
को आप जानते हैं ना.
here he relies on a judgment.
आप लावण्या देवी का जजमेंट जानते हैं ना,
हम
which says that it should be जो सेक्शन 4 का वेस्टिंग है, seller otherwise will not vest unless the land is utilized for the purposes of agriculture. जहाँ agricultural operation होगा सिर्फ वही वेस्ट नहीं करेगा, बाकी सब कौन वेस्ट करेगा. On the basis of yesterday he was placing that judgment. That is why I told him that you know what is the argument.
that judgment is also
So that judgment is binding on us. We really can't.
yes, absolutely. I'm not saying.
And therefore, so far as you claim that it did not vest by virtue of section, no basis. बाकी तो ornamental सिवायत है नहीं है, पार्टी है नहीं है, कॉस्ट टाइटल में ही दिख रहा है. You were representing yourself as सिवायत.
नहीं, ये केस में that judgment would not apply. In one case, there has to be a distinction between if the property was not settled by him and it remained the property of the
वो
landlord.
सारे वही सारा फैक्टर्स जो आप
नहीं,
बोल रहे हैं ना,
हम
वही
दूसरा
fact.
अच्छा ठीक है हम देख ले रहे हैं उसको हम डिटेल में देख लेंगे, लेकिन therefore it has to be understood as to what was the effect of BLR. Now BLR Act only affected the interest of the landlord, it did not affect any interest of the renter. So if the land, if it was not within the tenure of the landholder, that means the zamindar, and it was already
वो
settled.
जजमेंट जरा उनको दीजिए.
हम
अभी
देख-
जजमेंट
उसमें भी
देखिए.
सेटलमेंट सेटलमेंट
आप देखे होंगे कि नहीं देखे हैं पहले?
ठीक है हम देख लें.
आप पहले नहीं देखे हैं इसको, हम नहीं
हम
पास.
बहुत पहले पढ़े थे, लेकिन हम ये वाला नहीं है. हम श्योर कि ये दिस हैज नॉट बीन डेड.
यही वाला है. लाइए एक कॉपी लाएंगे मेरे लिए. साइटेशन
है कॉपी
नहीं, एक सेकंड हम अभी प्रिंट निकालें. रुक जाइए एक सेकंड. साइटेशन बताइए.
1994 सप्लीमेंट सप्लीमेंट्री 3 SCC 72
725
72
725.
हाँ 72
बॉन्ड का बहुत रिट्स डील किया है,
हाँ
लेकिन सेकेंड अपील फर्स्ट अपील पहली बारी है. सो इट हैज टू बी केयरफुली डिसाइडेड. वो भी अभी पेंडिंग है जो कल है. इसलिए कल तो हम एक सीनियर एडवोकेट मिस्टर शर्मा को सुने, आज नेक्स्ट सीनियर एडवोकेट मिस्टर राहुल गुप्ता को सुने, इसलिए एरर का कोई स्कोप नहीं.
हाँ ठीक है
अगर ये दोनों हमको ना सेटिस्फाई कर पाए तो हाई कोर्ट
टैंक एंड टैंकल इसमें भी शेड्यूल जो बनाए हुए हैं इस सूट इसमें भी टैंक है टैंक इसमें क्लियर है इसमें तो था
ये
भी
तो उसमें तो एक अलग से प्रॉपर्टी है,
हाँ
इसमें तो कुछ है ही नहीं।
क्लियर हाँ टैंक है इसमें तो क्लियर शेड्यूल
ठीक है।
लिखा हुआ अब 4.26 और उसमें कोई बाउंड्री भी नहीं है 202 और 203 क्लियर टैंक लिखा हुआ
और in spite of holding that it has vested in the state, how the decree was passed by the learned tribe?
वही तो
That error is there.
Very serious error is there. Very serious error. चलिए इसका फैक्ट्स पढ़ते हैं।
इसका फैक्ट्स
ज़्यादा लंबा नहीं है, कल भी
हाँ
पढ़ेंगे।
लेकिन ये लोग में
I will.
हाँ
But let's have a look at
ठीक है because
it. और कल से beyond थोड़ी हो जाए।
नहीं ये because I'm absolutely certain that section 4 itself within bracket it contains the word other than the interest of the rayat. So interest rayat
Rayati right
if the
will cannot be created as per this chapter on a property which is not used as exact.
So PLR Act comes in 1950. So it could not have been
Right,
affected prior to
everything
that.
this.
So if it did not belong the property of the landlord, then therefore that word is there, that protection has been given, that other than the rayati interest. That means if
आप थोड़ा इसको पढ़िए ना, एक पन्ना का जजमेंट
हम पढ़े
पढ़िए
alright.
ऊपर से पढ़िए।
Para 2 में वो है which your lordship is saying.
This is what it is. इससे निकलना थोड़ा मुश्किल है।
यहाँ पर भी रयती राइट जो बोल रहे हैं रयती राइट की बात ही इनका नहीं है क्योंकि तो लैंडलॉर्ड
इसमें भी
खबरदार है
the appellant was claiming rayati right
हाँ,
over the pawn.
हाँ
That claim, the rayati right over the pawn, has been rejected, specifically rejected. अब इसके beyond तो हम नहीं जा पाएंगे ना। आप बहस कर सकते हैं इसके beyond, हम जा नहीं पाएंगे। बहुत
हम बहस करने का मेरा रीजन है, हम नहीं बोल रहे हैं इससे बियॉन्ड जाने। Just in order to actually understand the effect of BLR. Otherwise, I would not. I'm absolutely, your lordship is absolutely. We all are bound by the judgment, whatever has been passed. But if the land, the BLR Act comes in 1950, Jamindar prior to that had absolute right of settling the land, whatever. There was absolutely no restriction on his right. So if a BLR Act comes in 1950, then and it only the Jamindari interest, whatever interest he had, that only vested. So if he had already settled some portion of the land and to a Rayat, and he had established that Rayat, then Rayati right did not affect at all. Rayati right was never affected by BLR. Even before the BLR Act, he was a Rayat of the Jamindar. After vesting, he became the Rayat of the state. That is the only difference that was there. So only landlord's right to collect rent and whatever landlord held the land, those were taken over, save and except section 5, 6 and 7. 5, 6 and 7 is whatever the landlord was holding as his own homestead, he was residing, all those land were settled to him without rent, and other portions of land in section 6 which he had was in khas possession, those were deemed to be settled to him. And that is the basis on which the K forms were submitted by the landlord and the state issued M form after verifying the detail. So therefore your lordship would find that in section 4 itself, it says that everything vests except the Rayati right of the right. But I do understand the effect of this judgment.
And you see, para number 3, just have a look at it by the operation. Can you read it?
By operation of section 4, such states or tenures including interest of the proprietor or tenure holder in such state or tenure and his interest in the trees, forest, fisheries, jungle, arts, glass, villa and ferry, and all other salati interests, as also his interest in all subsoil, including any right of mines in them, other than interest of the rayas and the rayas.
Other than therefore.
आगे
other than
आगे
other
हम समझ रहे हैं आप उसी पे हाथ करें
हाँ तो उसको तो हम the date of vesting vests absolutely in the state free from all incumbency and such proprietor or tenure holder shall cease to have any interest in such estate or tenure other than interest expressly stated by under the provisions of the Act. Section 6(1)(b) is one of the saving which postulates that on and from the date of vesting, all lands used for agricultural and or horticulture, which are in khas position of intermediary on the date of such vesting, including lands used for agriculture and held in the direct position of temporary lease of an estate or tenure and cultivated by himself with his own stock or by his own servants or by hired labor or with the hired stock, shall subject to the provision of section 7A and 7B be deemed to be settled by the state with such intermediary, and he shall be entitled to retain possession thereof and hold therein under the state having occupancy rights in respect of such lands, subject to payment of such fair and equitable rate as may be determined by the collector in the prescribed. The saving by section 6(1)(b) is only the lands actually used for agricultural process in the state or tenure of a lessee or temporary lessee and directly in his possession and cultivated by himself with his own stock or by his own servant or by hired labor or with the hired stock, and the land stands disputed and royalty rights have been confirmed statutorily subject to the terms contained in therein. The tank is said to be settled by the landholder in favor of land, thereby tank by itself. The tank is said to be settled by the landholder in favor of the land.
This is the main thing which is
the
coming
tank by itself.
in your way. Meaning thereby there is no concept of any private property. That's it.
After that.
Thereby the pre-existing right, if any, has been extinguished and stood divested. The appellant cannot claim any right on the basis of
Said agreement.
agreement.
Agreement
On
means that
basis of
agreement.
declarations.
Agreement means that agreement, settlement agreement. It's formed the basic declarations order.
अब आप एक बार जरा substantial question of law पढ़ लीजिए. In the light of whatever we have read both the judgments.
Yes. Whether the first appellate court has wrongly reversed the judgment and decree passed by the trial court by making out urban namas were not in terms of section 72 of the Chota Nagpur.
नहीं ये आपका last वाला portion छूट रहा है.
वो हमको भी लगा.
By making out the third case
हाँ.
that
हमारे पास
अच्छा.
that
आप print नहीं दिया उनको.
ये प्रिंट पे
कौन
नहीं.
दिया?
वो प्रिंट में लंबा पेज वाइज
जैसा
नहीं आ
होगा.
गया. ये 3 लीगल वाइज नहीं आया.
नहीं ठीक है.
आप लोग इतने
हाँ, हाँ,
expert लोग हो कि कैसे ऐसा error करते हैं?
वो कोई बात नहीं.
नहीं
नहीं,
ऐसे
उससे
कोई
कोई
कैसे
नहीं.
बात
हाँ
नहीं.
वो लीगल ना हम निकाले.
दीजिए. अब बताइए. Whether the first appellate court has wrongly reversed. Kindly read it.
Wrongly reversed the judgment and decree passed by the trial court by making out a third case that persons who had executed urban namas had only fractional interest upon the suit property. And second is Shruti Kirti Devya and other heirs and original plaintiff was not alone nominated surveyor, and urban namas were not in terms of section 72 of the Chota Nagpur. There's no doubt that all the three have been done. All these were not pleaded, and then also the appellate court goes into that question. So ultimately, Your Lordship, I do understand that the main question would be the settlement of the tank and what would be the effect of it.
You see, so far as reading urban nama is concerned, whether it has got the boundaries, whether it is mentioning about any details of the property, that can certainly be seen by the court. Even if the parties are not objecting to it, the court can see that. So far as section 72 of Chotanagpur Tenancy Act is concerned, certainly that is not pleaded, and the court may not have entered into that. What is section 72 of Chotanagpur?
It says that surrender to the landlord.
Yeah, and then settlement.
So
So one person cannot simply settle. I was just also surprised as to how.
here the question was not whether the Rayyat was surrendering to the landlord. It was surrendering to the entire case is it was surrendered to the deity. So there was no
So
question.
section, you forget about section 72.
Yes. And
But
other
there are other findings in connection with the Arpanama that the details are vague and all these
and
things.
they had only fractional interest, and that Shruti Kirti Devya had other heirs. All these things the appellate court goes into this question, although it was not pleaded. So only the other heirs who were not pleaded, they could have said that no, this was not pleaded and therefore it was not binding on me. They
The
could have-
only thing which is pleading here is that 1954 the property was already surrendered, already Arpanama was subject to Arpanama in favor of the deity or whatever. Is it?
Somewhere it has been recorded
And
in
then
division.
how that 1954 deed was, that property was again given
Yes,
to this Shruti Kirti
Yes,
Devi.
that,
By the, once it is transferred, it is transferred. This is something which is
Yes, yes.
very glaring, absolutely glaring as to how the same property can be given.
if it was already given to the deity, then
It could not have been. That is another thing, that she became the Shivai. She will continue to be the Shivai, but the property will be owned by the deity only.
yes.
So there was no occasion to give Arpanama in favor of, in her name. When the property is there with the deity, the Shivai would come one after another, but the property would be there with the deity.
Yes, and deity could have for some purposes, urgent purposes, he could have transferred it to
That is a different.
Yes, but here it that question.
That question is not arising here, right? So we will take care of that.
Yeah.
Okay, next one. What is
Whether
this?
the learned lower appellate court was right in holding that Exhibit 3 was the conclusive proof of possession as per section 84(3) of the code.
What was exhibit?
What he said,
Revision survey record of right has also prepared in the report. That is exhibit 3.
no,
Huh? Yeah, but
ये बोल रहे हैं दूसरा चीज सिर्फ लॉ पॉइंट है अदरवाइज what he says is the lordship would find at internal page 28
28. Yes.
I further find that during the recent regional survey, Times recorded as Khata number 91 in the name of Rawat Yasser and finally published on 21st February 1991, which is crystal clear from exhibit 3 and the same is conclusive proof of possession as per section 84(3) of CMT. This is recorded.
So they are referring to the
Judgments.
finality of.
no I
entry.
further find last approximately 10 lines I further find that during the recent revisional survey the tank is recorded under RS Khata number 91 in the name of Arnabad Bihar Sarkar and is finally published on so and so, which is crystal clear from exhibit 3 and the same is conclusive proof of possession. This cannot be conclusive proof of possession. There is only
It
a
is one thing
presumption
to
of
say, it is one thing to say that there is nothing contrary on record to
yes.
disprove it.
And the section itself uses the word that there would be a presumption of correctness of the
See,
entries.
the section says that there is a presumption of correctness, but that entry is not under challenge.
No.
You have not challenged that entry.
So what would be the effect despite if it is recorded, then only consequence is that there would be a presumption of correctness. That is all. It can never be conclusive.
इसमें अर्पणनामा के बारे में यहाँ पे कहा गया था, उसमें भी आया कि इसमें ये डिस्क्रिप्शन है, आई फर्दर फाइंड दैट नाइदर खाता नंबर प्लॉट नंबर हैव बीन शोन इन द अर्पणनामा, डिस्क्रिप्शन ऑफ द सूट प्रॉपर्टी हैज नॉट बीन मेंशन, ये भी अपडेट कोर्ट ने ऐड किया है।
ये किसमें है?
ये जो हम अभी
एक सेकंड, कंक्लूसिव प्रूफ या प्रिजम्पशन किसमें है?
84 सबसे
84 में
Every entry in a record of right so published shall be evidence of the matter referred to in such entry and shall be presumed to be correct.
Presumed to be correct.
Correct
That is-
until it is proved by
Yes,
evidence
yes,
to be
yes,
incorrect.
yes, absolutely.
So, if you want to prove that this particular entry is incorrect, is it necessary to
I have
challenge
to
that
read
entry?
evidence to show that the entry, although it records so and so, but that is not correct.
No, was there? So naturally, you were challenging the entry also.
So
Were you challenging
here,
the entry also.
this question I have, this question was, I was only aggrieved by the word, it is a conclusive proof. The section itself that there is only a presumption that goes along with it, along with the entry, it can never be conclusive.
So the point is that did you challenge the entry?
No.
If you did not challenge the entry, the matter ends.
Your Lordship, in another proceeding, whether
No, you
In a-
forget about other proceedings.
Yes.
We want to know that in the suit, did you challenge the entry?
in the suit I have said,
Because we are coming across various suits where the entry is specifically challenged. In the prayer also it is challenged.
No,
That this entry is incorrect,
No
it
relief
should be
has-
rectified.
no relief has been sought.
So no relief has been sought
so
with regard to the
whether,
entry made.
whether that
Nor
entry-
there is anything in the suit also, we have seen, we have read it, with regard to this entry.
it is
This
altogether,
entry is at best an entry of possession, isn't it? At best.
yes,
By itself it is not creating any title. But this entry is at best an entry of possession. So this particular entry, and coupled with the fact that the government has been auctioning this property from time to time, this entry, there is a presumption attached to it, and this is the finding.
that I am not disputing. I am only saying that whatever, if ultimately if this is upheld as conclusive proof, then that would
We are not going to uphold it as conclusive proof,
be,
but
it only says, and
we will
whether,
only say that it has to be interfered and considered if it is under challenge.
and whether I am required to, if there is an adverse entry in record of right, whether if I file a suit, whether I am required to make a specific prayer with regard to the entry.
Even
I'm
if not,
I can only show, I can show
Even
that
if-
the entry is wrong.
even if you do not make a specific prayer, by abundant precaution, people are making
Yes, yes,
specific prayer. Correct? And then also, it has to be challenged somewhere in the plaint.
It has only thing what is required, that the entry was not correct, and despite such entry, I have a right on the
So
property.
your case was
Yes.
that in spite of this entry, you have a right. So suppose your title is declared that this entry will be meaningless completely. Then ultimately what will happen? The circle officer has to make entry pursuant to the decree passed in your favor in case you succeed. Suppose you succeed in establishing your title over the property, and your claim that you are a rayat of the pond is upheld by this court, then circle officer will have no option but to rectify the entry and give you a rent receipt.
So, if your lordship, in terms of section 83, 84, 87, those are the modes where entry has to be made, challenged, and entry has to be corrected.
Yes.
Now, once till 87 the matter has come, Now in a separate suit, can I pray for it? Only a ultimate effect of the entry is that there is a presumption of correctness. That is all what I am saying.
That's
I'm
it.
not
It
saying
is
that.
not a
Now
conclusive
in a
proof.
separate suit, I cannot. I'm not required to say that please direct as is required in cases of a registered instrument, that please declare it as cancelled or something. So here only another is that whether the learned lower appellate court was right in discarding exhibit B 1 by B and 1 by C on the ground that they were beyond pleading. It was not there in the plea.
1 by B and 1 by C.
There are altogether only 2 urban namas which have been mentioned in the plea.
It is beyond pleadings.
And there were 2 were not mentioned, and these 2 we have altogether we have brought 4 urban namas, and these are the 2. So they were beyond pleading that. But here, Your Lordship, my submission was that in terms of section order 6 rule 2, only statement of fact has to be mentioned and not the evidence by which I have got the title. So here difficulty is there whether this will be taken or not. Now
Yeah,
the fourth,
not the foundational pleading here. How are you acquiring the property? Otherwise, so you will say that I am the owner of the property and that's full stop. And then you will give all the evidences.
Evidence divorce pleading, that cannot be accepted.
फाउंडेशनल प्लीडिंग तो देना होगा, रजिस्टर्ड डॉक्यूमेंट है तो आपको वो तो बताना पड़ेगा. How are you deriving property? आपको बताना. Anyways,
next
without
year,
meeting the reasons, इसमें क्या है, कौन सा
whether
reason?
the
There is a concurrent finding that it vested in the state.
No, he does not even discuss the finding of the trial court, but and whether the lower appellate court was right in reversing the judgment and decree passed with the trial court on the ground that deity was not made. So this was not
Is this
required.
the ground of the appellate court? to reverse
Appellate
it?
court it says
That is the sole ground.
no.
That is not the sole ground. So it is immaterial technically.
It is not this one. Other grounds are there.
Other grounds are also there. So deity, if not made party separately, although the plaintiff claimed that he was representing the deity. First title में तो वही लिखा हुआ that he was representing.
And Your Lordship, ultimately that
Section
whether
4
it
will
had vested or not,
everything will boil down to that. तो इसमें वो कहाँ बना है?
इसमें नहीं.
नहीं बना है.
So
एक सेकंड नहीं बना है. And there are concurrent finding on this. तो इसको आंसर करके हम क्या करेंगे? आप ही बताइए. ट्रायल कोर्ट का फाइंडिंग है, फिर भी डिक्री हो गया. एपलेट कोर्ट का भी फाइंडिंग है, नहीं इंटरफेयर किया. आपने तो कोई क्रॉस अपील नहीं फाइल किया. कोई क्रॉस,
this is my appeal.
नो दिस इज योर अपील फर्स्ट एपलेट कोर्ट में कि भाई ये फाइंडिंग तो गलत है ना. भाई आपका तो सूट डिक्री हो गया.
अब डिक्री हो.
इररेस्पेक्टिव ऑफ द फैक्ट कि वेस्ट कर गया, फिर भी आपका डिक्री हो गया. गलत है ना.
गलत है लेकिन Your Lordship there is
हाँ, ये
I
तो
was
अपील
not
फाइल.
no here if the Supreme Court judgment the Honorable Court has said that if ultimate decree was in my favor, then I was not required to file an appeal. I cannot file an
नहीं,
appeal
तो
against a finding.
जब आपका फर्स्ट अपील हुआ,
हाँ.
it was open to you to challenge that finding either during the course of hearing, right, or by filing a cross objection. दोनों आप कर सकते थे. कोर्स ऑफ हियरिंग में भी लेट मी एज्यूम फॉर अ मोमेंट दैट यू कुड हैव. कहाँ है? और हम लोग सेकंड अपील में है, उसका कोई सब्सटेंशियल क्वेश्चन ऑफ लॉ भी नहीं बना है.
वो नहीं लेकिन
क्या आपके फेवर में?
लेकिन हाँ, I was not required to file a separate appeal.
Yes, but still, it was open to you to make oral arguments.
हाँ,
It was also open to
challenging
you.
the finding. Yes,
वो आप
challenging
कर
the
सकते थे oral arguments.
challenging the
आप ये भी कर सकते थे कि एक क्रॉस ऑब्जेक्शन फाइल कर सकते थे.
हाँ.
दोनों आपने नहीं किया. और ये पर्टिकुलर फाइंडिंग वाज सो मटेरियल टू द केस. इट वाज द कोर ऑफ द मैटर. और यहाँ पे एपलेट कोर्ट का भी फाइंडिंग है सेक्शन 4. और अभी आप हमको बोलिएगा कि सब्सटेंशियल क्वेश्चन ऑफ लॉ है तो नहीं है. क्योंकि जजमेंट है सुप्रीम कोर्ट का डायरेक्टली
हाँ, वो
कवरिंग,
ठीक है।
देयर इज नो सब्सटेंशियल क्वेश्चन ऑफ लॉ। तो ये सब क्वेश्चन को आंसर करके हम क्या करें बताइए, कुछ है इसमें? जबकि इतना सुन के हम बनाए, फिर भी हम बहुत केयरफुल रहते हैं सब्सटेंशियल क्वेश्चन ऑफ लॉ बनाने में।
नहीं तो this is only for the purpose of admission. The questions of law, it is absolutely not possible for the honorable court to give 1 hour and then to admit it after 1
नहीं
hour.
नहीं, इसलिए जरूरी हो जाता है।
Whole purpose
हो
is that
सकता है कि अगर उस वक्त आपने ये क्वेश्चन ऑफ लॉ बनाया होता सेक्शन 4 VLR एक्ट का, तो हो सकता है हम उस वक्त हम इस पॉइंट को भी फॉर्मुलेट कर लेते, क्योंकि ये जजमेंट तो मैंने तब तक नहीं देखा था दैट द इशू हैज ऑलरेडी बीन डिसाइडेड बाय द सुप्रीम कोर्ट व्हिच इज बाइंडिंग ऑन मी। लेकिन आज के दिन में जब हम एडिशनल क्वेश्चन ऑफ लॉ के बारे में सोचे भी कि भाई चलिए प्लेंटिफ है, कुछ छूट गया काउंसिल से, लेकिन वो भी नहीं बना पाए क्योंकि ये द इशू इज ऑलरेडी सेटल्ड, देन आई एम नॉट सपोज्ड टू फ्रेम एन एडिशनल सब्सटेंशियल क्वेश्चन ऑफ लॉ एंड ही विल अपोज इट।
no, even otherwise I'm not even.
सो जब आपका सेक्शन 4 का इशू आपके अगेंस्ट में फाइनली डिसाइडेड, तो ये सब इशू डिसाइड करके हम क्या करें?
So I'm as of now I'm raising this ground of section not vested, but
नहीं नहीं,
Your
आप
Lordship-
कहाँ raise कर रहे
नहीं
हैं?
नहीं,
आपका
I'm arguing your lordship may reject my argument.
नहीं नहीं,
I say that.
I will not say anything. Why should I? I will only confine
In-
myself to the substantial question of law as framed. उसके beyond हम देखेंगे नहीं।
तो उसका तो हम बोल रहे हैं कि वो वेस्ट किया है, the finding of the both the courts below on the vesting is wrong.
आपके बोलने से नहीं होगा ना, कोई सब्सटेंशियल क्वेश्चन ऑफ लॉ नहीं बना है तो आपके बोलने से हम कैसे इसको डिसाइड करें? नहीं कर पाएंगे।
यही appellate court ने held किया है। I further find that Arpanama that had appointed Smriti Kriti Sevai authority, but in this Arpanama description of the suit property had not been mentioned. And I further find that neither khata number nor plot number has been shown in Arpanama.
हम लोग अभी भोपाल गए थे ट्रेनिंग के लिए, सिविल लॉ का ही ट्रेनिंग, दैट वाज द स्पेसिफिक असाइनमेंट, और हम लोग इसी कंक्लूजन में पहुंचे कि सब्सटेंशियल क्वेश्चन ऑफ लॉ फ्रेम करने के पहले बहुत इत्मीनान से सुन के फ्रेम करना चाहिए, ऐसे नहीं फ्रेम करना, क्योंकि बहुत सीरियस एरर्स हो जाते हैं और बाद में हम लोग बिल्कुल ही हेल्पलेस हो जाते हैं। It is not like that. हो गया?
Your lordship may continue it tomorrow.
अच्छा ऐसा
Only-
है, आई विल कंटिन्यू इट टुमारो, लेकिन जितना थोड़ा कैप्चर कर लेते हैं आप लोग का रेस्पेक्टिव आर्ग्यूमेंट्स, उसके बाद जिससे कि हमको अपना जजमेंट फाइनली दिखाने में ज़्यादा टाइम नहीं लगेगा,
ठीक,
ठीक है? और the learned counsel is appearing on behalf of the parties.
your lordship may only excuse.
हाँ हाँ sure. This appeal has been filed against the judgment and decree dated 31st of August 2022 with the bracket decree sealed and signed on 13th of September 2022 bracket rules passed by learned District Judge Romanji Dhanbad in Civil Appeal number 126 of 2019. The learned First Appellate Court has set aside the judgment and decree dated 12th of October 2018, with the bracket decree sealed and signed on 26th of November 2018. Passed by learned Additional Civil Judge with the bracket Union Division, bracket Dhanbad, entitled suit number 114 of 2005. The learned trial court had decreed the suit. The first appeal was filed by the defendant state and
First appeal filed by ये ना first appeal
was filed by the defendants,
I state this.
and the present second appeal has been filed by the plaintiff singular against the judgment of reversal. The appeal was admitted for final hearing by the order dated 24th of February 2025 on the following substantial questions of law. The learned counsel for the appellant may I seek. The suit was filed for declaration that the tank mentioned in the schedule was not a government Sara, rather it was the property of Shiv Mandir, Bakaspura, through Arpan Namas, and the plaintiff was the Shivayat of the deity. Further relief was prayed seeking confirmation of possession and alternatively for recovery of possession if the plaintiff is found dispossessed from the tank during the pendency of the suit. A relief was also prayed seeking permanent injunction restraining the defendants and their agents from settling the tank by holding public auction. The schedule of the property was District Dhanbad, PS Govindpur, within bracket now Barwadda, bracket close, comma Moza Bakaspura, comma Moza number 77, Khata number 55, plot number 202 and 2203, total area 4.86 acres, comprising of tank and tank ends. The specific case of the plaintiff was that the suit was recorded as Gair Abad Malik land in cadastral survey record of right under Panchula the Sondi as Khebardar, who gifted the tank to the Shiv Mandir by registered Arpannama number 76 dated 17/1/1923. And the produce of the tank was used for worship and management of the Shiv Mandir. Upon his death, co-sharer, namely Bakuntanath the Sonni, also made Arpannama of his share of the tank by registered deed number 226 dated 17/8/54 for the said Shiv Mandir and appointed Srimati Shruti Kirti Devi, mother of the plaintiff, as Shivayat. The mother of the plaintiff continued to possess and manage possess the tank and manage the affairs of Shiv Mandir. Through khavats by selling fishes. After vesting of zamindari, the name of the mother of the plaintiff was entered as Shivayat / Rayat for the tank, and she used to pay rent to the state of Bihar and continued to possess the property. And after her death, the Shiv Mandir was being managed by the plaintiff, but the plaintiff could not continue to pay rent for the tank. The grievance of the plaintiff was that the tank was being settled by public auction through District Fisheries Department, and consequently he made an application before Land Reform Deputy Collector Dhanbad to stop further auction of the tank, and upon a report his application was rejected by the order dated 25/6/2004, and the appeal was also rejected by order dated 25/4/2004, and the appeal was also rejected by dismissed by order dated 25/5/2005, observing that tank cannot be settled to plaintiff and it was under the charge of the Fisheries Department. It was the specific case of the plaintiff that the tank remained the property that the tank belonged to Shiv Mandir, and it never vested in the state government under the provisions of Bihar Land Reforms Act, which remained the property of Shiv Mandir. And at the time of vesting of zamindari, the tank remained as Rayati tank of Shiv Mandir, which cannot be settled to public by auction as it was not in government setup. The defendants कोई मंदिर के प्रॉपर्टी की का वेस्टिंग को लेके कोई अलग से प्रोविजन तो नहीं है बिहार लैंड रिफॉर्म्स एक्ट,
वही बिहार लैंड रिफॉर्म,
ठीक, मतलब कोई अलग से कोई सेक्शन तो नहीं है
नहीं,
ना,
अलग।
मंदिर का कोई जमीन नहीं वेस्ट करेगा या मंदिर का कोई प्रॉपर्टी
वेस्टिंग के लिए तो यही है।
The defendants who was the state and their authorities filed a written statement and took a specific plea that the suit was barred under Section 4 of the Bihar Land Reforms Act and was not maintainable. And the same was, and the tank was being settled by the Fishery Department every year, which was sufficient to show that the plaintiff did not have any possession over the suit property. It was their specific case that all the tenure rights in government tanks vested in the state of Bihar after coming into force of Bihar Land Reforms Act. And the temple was situated by the side of the tank, and therefore cannot be owned and possessed by the plaintiff. It was also stated that the tank had no relationship with the temple. It was a public tank, and the statements made in the plaint was quite denied. The learned trial court framed the following issues for consideration. Court continued. उसके बाद पैरा 4 and 5 दोनों कोर्ट करेंगे ट्रायल कोर्ट। the learned trial court by the learned trial court specifically considered the matter by recording at internal page 18 of the trial court judgment that the issues involved in the suit was as to whether after dedication of the tank to Lord Shiva by Arpan Namas, Lord Shiva became Rayyat and rightful owner, and whether suit tank used for puja purpose of Lord Shiva at Bakaspura, क्या लिखे हैं यहाँ पे? ये last वाला portion है. The ये शायद it's a part of the argument of the plaintiff.
हाँ वो part of
हाँ ठीक है.
16 में
हाँ एक the learned para number 16. The learned court first took up issue number 4, that is whether the suit was barred under the principles of section 4 of the Bihar Land Reforms Act. And the learned court ultimately came to a finding that finding as follows. देखिए तो क्या है from the discussions, page number 26. Quote करिएगा. From the discussions of provisions of Bihar Land Reforms Act and Bihar Land Reform Rules, it is clear that the present suit is not barred under section 4 of Bihar Land Reforms Act 1950. Full stop. As present suit is not brought in respect of any entry in or omission from a compensation assessment rule or in respect of any order passed under chapter 2 to chapter 6 or concerning any matter which is or has already been subject of any application made or proceeding taken under the same chapters. Full stop. Accordingly, this issue is decided in favor of the plaintiffs. Plaintiff singular. Thereafter, by paragraph 15, the learned trial court considered issue number 5 as to whether the suit property, that is tank, was the property of Shiv Mandir through Arpan Namas, and as to whether the plaintiff was a Shivayat of the deity. The learned trial court decided the issue by ultimately recording a finding that the suit was recorded as Gair Majulka Malik in the last cadastral survey in the record of rights, showing Panchulal Dasodi as Khewardar. The plaintiff had filed Form M, in which the name of his mother was mentioned as tenant and rent was fixed for suit land after undertaking proceedings under Bihar Land Reforms Act. His mother was paying rent to the government of Bihar. The plaintiff has proved through documentary evidence that his predecessors have surrendered / settled / gifted suit pawn in favor of Lord Shiva and appointed him and his predecessor as Shivai through various Arpan Namas which were exhibited and ultimately held that Lord Shiva is a legal person in the eyes of law and he is capable of holding property, and on the basis of the discussions made, this issue was decided in favor of the plaintiff. The issue number 6 as to whether the sultan vested in the state of Bihar, now Jharkhand, was considered by paragraph 16, and the trial court ultimately held that the suit bond is registered as Gair Awad Malik, and it is admitted by plaintiff himself that it is entry as government Sarat, it has entry in as government Sarat register, and ultimately held that the suit bond was vested in the state of Bihar, now Jharkhand, and entered as government Sarat. With respect to issue number 7, the matter was taken up in paragraph 17. The learned trial court recorded that the plaintiff proved that the suit bond was in possession of his predecessor and also in possession of the plaintiff since 1923, and Panchul the Saudi was shown as Khevardar in CS Khatian, White Exhibit 3, and the rent was assessed till the year 1956-57 in the name of the mother of the plaintiff, and rent receipts were issued, which were exhibited as Exhibit 7, and all the witnesses had supported that the suit bond was in possession of the plaintiff and his predecessor, and they were managing the temple of Lord Shiva from the income arising out of fishery in the pond. The learned trial court further recorded that the defendant were claiming that the pond was a public land and property of the government, but the defendant did not file any documentary proof in support of their claims. However, it was admitted that the suit bond was registered as Gair Awad Malik land. The suit land was registered in the name of government of Bihar and thereafter state of Jharkhand, but was in possession of the plaintiff and his predecessor since 1923. The plaintiff brought the suit only when the defendant auctioned the bond in favor of third parties. The trial court further held that further decided the issue in favor of the plaintiff by observing that the defendant failed to prove that the suit bond vested in fishery department. As no circular or any gazette notification was brought by the fishery department, the learned trial court ultimately recorded a finding that the suit land was in possession of the plaintiff since 1923. The issue number 8 was ultimately decided in favor of the plaintiff. The learned trial court ultimately decreed the suit on contest, and it was declared that the tank mentioned in the schedule was not a government sara, rather it was a property of Shiv Mandir, Bakaspura, through its Arpanama, and the plaintiff was the Shivayat of the deity. The possession of the plaintiff was confirmed against the defendants, and alternative for recovery of possession if plaintiff is found dispossessed from the tank during pendency of the suit. The decree for permanent injunction restraining the defendant, their men, agents and officers, staff, etc. by holding public auction was decided in favor of the plaintiff. This court finds that the learned trial court, in spite of holding that the property vested in the state of Bihar while deciding issue number 6, still declared that the tank was not a government setup and was property of Shiv Mandir. However, the fact remains that the possession of the plaintiff and their predecessor was declared over the suit bond since 1923. So far as the appeal was filed by the defendants. So far as the learned first appellate court is concerned, the impugned judgment shows that certain documents were produced on behalf of the defendants before the learned first appellate court by way of additional evidence, but the additional evidence was rejected by the learned first appellate court. No substantial question of law has been framed by this court in connection with refusal of additional evidence at the first appellate stage. This court also finds that the learned first appellate court recorded the moot question for determination in paragraph 13 as under. The learned first appellate court, after considering the materials on record, has given its finding in paragraph 15 of the judgment. And has in particular dealt with the provision of section 4 within bracket A है वो?
हाँ A,
That is 4A.
हाँ 4A,
नहीं?
हाँ 4A,
Section 4 ही तो है.
हाँ 4A है.
4A है लेकिन 4A जो कोट किया है वो 4A तो नहीं है. और ये तो डिवीजन है.
नहीं. Consequences of adjusting of any state or division.
ये 4 है ना, ओनली 4 है. एपेलेट कोर्ट ने 4 कैपिटल A लिखा है.
4A small A तो है.
एपेलेट कोर्ट का जजमेंट देखिए तब आप. Has specifically referred to section 4 of the Bihar Land Reforms Act. And also other materials placed on record. And held that during the recent surveys recent revision survey, the tank is recorded under RS Khata number 91 in the name of Annabad Bihar Sarkar and is finally published on 21st of February 1991, which was crystal clear from Exhibit 3. And observe that Exhibit 3 was the conclusive proof of possession as per Section 84 within bracket 3 of Totonaco Tenancy Act. And observe that as per this section, every entry made in record of right so published shall be evidence of the matter referred to in such entry and shall be presumed to be correct until it is proved by evidence to be incorrect. The learned first appellate court also observed that neither the sole respondent, neither the plaintiff nor any survivor filed any objection against the entry made under section 87 or 89 of the Totonaco Tenancy Act, and further referred to the judgment passed by this court reported in JLJR 2003 within bracket 2708 in judgment निकाली JLJR 2003 volume 2 708 High Court का ही होगा, that recording is final and conclusive proof of possession. The learned first appellate court also recorded that the tank in question was being auctioned and the plaintiff never made any objection prior to filing of the suit in 2005. And the plaintiffs were praying before the revenue authorities for settlement of the same. The learned first appellate court also recorded that the documents, that is Arpannamas, dated 17/1/1923 and 17/8/1954, does not mention the details of the land and they only related to the management of the Shiv Mandir . It also recorded that the Arpannama dated 17/1/1923, which was executed by Panchu Lal Dashodi, was executed prior to cadastral survey record of right, and there was mentioning of khata and plot. The learned first appellate court took judicial notice that after preparation of cadastral survey in the year 1925, the plot numbers and khatiyans came to picture, and in the Arpannama dated 17/1/1923, there are boundaries given, but no details have been mentioned therein. It was also observed that the document showed that there are other co-sharers, and through this Arpannama, Panchu Lal Dashodi made these documents only to the extent of 3 annas share. The learned first appellate court further gave its findings in connection with registered deed number 226 dated 17/8/1954 within bracket Arpannama, which was marked Exhibit 1 by A, and observed that even in this document the details of the suit property has not been mentioned. The learned first appellate court further recorded that the Arpannama has been described, has further recorded that the Exhibit 1 and 1/A, the two Arpannamas may be said to be gift and therefore the required procedure for execution of gift under section 123 of the Transfer of Property Act should have been adopted. The first appellate court further recorded that Arpannamas have been shown as surrendered before deity, but under the provisions of section 72 of Totanagpur Tenancy Act, the surrender has always to be made by the Rayyat and not the Khevat holder, and the executant of Arpannama, Panchu Lal Dashodi, was a Khevat holder. The court also recorded that section 72 of Totanagpur Tenancy Act showed that surrender will exclusively be done by Rayyat in favor of the landlord. The learned first appellate court went on to record that the outgoing intermediary at the time of vesting had not filed return, and as such property was vested to the state government, though the plaintiff/respondent had filed a copy of return, Exhibit 4, but in the return the property under dispute did not find place. And it was only after vesting of zamindari interest the name of mother of the plaintiff, namely Suti Priti Devi, was entered as Sebayat/Rayyat for the time, and she used to pay rent to the state of Bihar and continued to possess the same for the same purpose. And after her death, the plaintiff continued to possess the tank. The learned first appellate court recorded that the property is tank and tank only, and in the case of the plaintiff, the tank existed since long prior to vesting of intermediary right, but no return was filed for this property, and as such the property belonged to the state government. The learned trial court, the learned appellate court further referred to the judgment passed by this court in first appeal number 43 of 2012 to observe that mere issuance of M-form with respect of such land cannot protect these lands from vesting.
Which is pending.
Thereafter, sorry?
Which is pending before your legislature.
सुन लिया है उसको? ये फर्स्ट अपील
43 2012
हमारे पास कोई पेंडिंग हुआ है?
ये 43 FA 43 2012 जिसका कंटिन्यूअस
यही है क्या? ये तो सेकेंड अपील है।
ये नहीं
किस फिर कौन सा?
ये जो जिसका रेफरेंस ये ले रहे हैं जिस जजमेंट का FA 43 2012 which is already pending before your legislation.
ये पेंडिंग नहीं है तो फाइनली डिसाइडेड है लग रहा है।
उसकी ये सुप्रीम कोर्ट से फिर जो रिमांड होकर के आया
अच्छा
है
वो वाला है।
तो वही तो है।
कोई सहारा इंडिया कमर्शियल
ओ सहारा।
हो सकता है मेरी बस
तो इसी
उदय शंकर फॉर्म
that was my submission.
I will just record your submission. Don't worry. अभी तो आधा ही लिखा रहे। देखिए आज इतना सुने थोड़ा लिखा दे रहे, कल तो फाइंडिंग लिखा दे बस सीधा। फाइंडिंग या थोड़ा आप लोग का जो आर्गुमेंट्स हो गया ये इतना खोल के पढ़ लिया है ना तो लिखा लेना ठीक है, तो बहुत टाइम वेस्ट हो जाता है। At this stage, the Learned Counsel for the Appellant has submitted that the judgment passed in FA number 43 of 2012 has been set aside by the Honorable Supreme Court in SLP civil number जो भी है आप दे देंगे उसको वो तो होगा ना मिस्टर राहुल गुप्ता ही कर रहे हैं उसको
यस 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 वो रेफर्ड होकर के फिर डिमांड बैक हुआ है
सेट असाइड होके डिमांड हुआ है ना
जी
सेट असाइड होके ही डिमांड होता है
Set aside.
SLP का नंबर ठीक है and the matter is now pending before this court. This court further finds from the first appellate court's judgment that the first appellate court considered the oral evidences and recorded that the witnesses of the plaintiff, including PW 5 and 6, witnesses of the plaintiff has themselves stated that the suit that a disputed tank was being used for general public and was being auctioned by the state government. Particular reference has been made to PW1 and PW4. The Learned First Appellate Court ultimately held that the Learned First Appellate Court observed that after perusal of the judgment of the Learned Trial Court as well as the materials available on record, held that the relevant facts as pointed out by the Learned Counsel for the defendants who were appellants before the first appellate court were not discussed and considered by the Learned Trial Court. The Learned First Appellate Court ultimately declared that the tank mentioned in the schedule of the claim was not a government SEDA the Learned First Appellate Court ultimately held that the declaration made by the Learned Trial Court that the tank mentioned in the schedule of the plane was not a government SARA, rather it was a property of Shiv Mandir, was incorrect. The Learned Trial Court had wrongly confirmed the position of the plaintiff. And the Learned Trial Court had wrongly granted permanent injunction restraining the defendants from settling the tank through public auction. And consequently, the trial court judgment and decree was set aside by the Learned First Appellate. The Learned Counsel for the Appellant during the course of arguments has submitted that there is an additional substantial question of law involved in this case as to whether the property being the Rayati pond of the plaintiff, of the deity, through the Sevayat, vested in the government by virtue of Section 4 of Bihar Land Reforms Act. The Learned Counsel.
Four small.
Four small and it's 4.
Only 4.
Only 4 ही बोलने से हो जाएगा ना, एक ही
हाँ 4 में तो पूरा आ जाएगा.
पूरा आ जाएगा. The learned counsel has submitted that unless the learned counsel has submitted that there are concurrent findings recorded by both the courts in connection with vesting of the property with the state government by virtue of section 4, and unless this finding is set aside, no relief will be ultimately given to the plaintiff. The learned counsel has in particular referred to section 4 within bracket A and has submitted that the interest that as per the provision of vesting, only those interests stood vested in the state which were other than the interest of rayats and under rayats. He has submitted that since the property was a rayati pond, therefore it did not vest with the state government.
It is the case of the appellant.
उन्हीं का submission. The learned counsel for the respondent has opposed the prayer and has submitted that no such question of law arises for consideration by this court in view of the law settled by the Honorable Supreme Court reported in 1994 supplementary within bracket 3 bracket close SCC 725
727. Sorry.
725
725.
within bracket Lavanya Bala Devi versus State of Bihar, and I submitted that in the same case also rayati right was claimed over pond and the same was specifically rejected by the Honorable Supreme
Okay, tank
Court.
and tank.
And over the pond near tank,
हाँ एक ही.
and the same was rejected by the Honorable Supreme Court by holding that no rayati right can be claimed over tank, and the tank which was said to be settled by the landholder in favor of the appellant of the case was not saved by virtue of section 6 within bracket 1 within bracket B of Bihar Land Reforms Act. The learned counsel has submitted that
Pre-existing right.
that the pre-existing right over the tank / Saryat does not exist upon vesting. He has submitted that the law having been settled by the Honorable Supreme Court, the same cannot be framed as a substantial question of law to be decided by this court. ठीक है? सब कल लिखेंगे. पता नहीं इस पे आगे क्या बोलेंगे, इसलिए we do not know.
ठीक है.
At the request of the counsel for the appellant, pose this case for further dictation tomorrow. It will be open to the counsel for the parties to for further hearing. ठीक है? मेरा तो काम 50% तो हो ही गया, more than that. Sort of policy.
I'm requesting that since I have talked to senior, I have instructed that to put this case on tomorrow.
वो तो ऑर्डर हो गया, अब तो साइन भी कर दिया मैंने. भाई एडवोकेट क्लर्क एसोसिएशन को देने में आपको क्या तकलीफ है? आपके एक पॉकेट से पैसा निकलेगा, दूसरे पॉकेट में जाएगा। आई विल नॉट चेंज माय अब देखिए साइन करने के बाद हम काट नहीं सकते, ठीक है? कुछ नहीं होगा, आप अगला
Item 5, first appeal 37 or 2024.
दिस वाज पास्ड ओवर।
हाँ
इसको नहीं करना।
सर्विन चौधरी वाले के इसमें
बताइए क्या?
एमएनडी एसटी आई हैव नॉट गॉन थ्रू
एक सेकंड पहले थोड़ा सा समझने दीजिए कि कितना लंबा मैटर है, नहीं तो छुट्टी के बाद भी क्या मैटर है
मैम
बताइए।
ये चैलेंजिंग अवार्ड
वो लैंड एक्विजिशन है,
हाँ, land
ये तो छोटा सा मैटर होगा, इसमें तो ज्यादा कुछ होगा नहीं।
acquisition।
क्या चीज चैलेंज कर रहे हैं?
अवार्ड नंबर 13 related to commercial valuation of the house
वैल्यूएशन ऑफ द हाउस और वैल्यूएशन ऑफ द
the
लैंड
land
क्या रेट से दिया है आपको बताइए। क्या रेट लगाया है?
I'm not aware of the date
You are not aware of the price. आप पैरा नंबर 10 एंड 11 पढ़िए। 10 एंड 11 दोनों पढ़िए तो
10 and
हाँ बस इतना ही है आपका बस पढ़िए। पैरा 10 पेज से लेके नहीं अपना मेमो ऑफ अपील हम आपको असिस्ट करते हैं, अब आप पढ़िए ठीक है। थोड़ा समझने दीजिए कि ज़्यादा नहीं है इसका। आप जाइए बताइए, देखिए पैरा 11 यू जस्ट हैव अ लुक।
that considering the evidence available on the record, the learned court had enhanced the compensation with regard to award number 4 from rupees 10,79,535 to rupees 25,24,128. And so far with regard to award number 13, there was no further enactment in compensation. That is, the compensation remained at rupees 5,59,910 as awarded by the land acquisition officer. Therefore, by judgment dated 15/06/23 and decree dated
अवार्ड नंबर 4 कहाँ है? दिस इज अवार्ड नंबर 13
yes,
and where is award number 4? Was it exhibited? This is award number 7. तो अवार्ड नंबर ही आपका गलत लिखा है। Award number 4. इसमें तो अवार्ड नंबर 7 है आपका सर्टिफाइड कॉपी। आप सही डॉक्यूमेंट लगाएं। Where is award number 4? It must have been marked exhibit. आप पढ़िए तो पेज नंबर 24 लगे। So far as award number 4 is concerned.
so for
मिला? Running page 24, internal page 10.
so for the award number 4, which is related to the land is concerned as exhibit number 6, Ashutosh Pandey got information from district assistant Jharkhand public information officer regarding desired minimum valuation of the land rate per decimal. Above information was provided to him on 21/12/2021, but from the above information it is not clear that which year valuation is this. On the other hand, objective state has got exhibited circle rate of the land of the year 2017 and
as Exhibit A in the land acquired in the year 2008. Continuing to mention here that in this case, petitioner body has not filed registered sale deed of the adjacent land to the acquired land which was sold out in year 17. To show that what was the rate of the land in the vicinity of the acquired land, and the tribunal has no option but to rely on the Exhibit A as per the Exhibit A property valuation for award number 12 is 1,19,007. 11,97,859 for residential per decimal. 14,37,430 for urban residential market. 23,95,780 for urban commercial. And 28,74,861 for urban commercial market. In this case, while deciding issue number 1, tribunal has held that the acquired land is in urban residential market area. Hence, as per Exhibit A, valuation of the land per decimal situated in urban residential market for award number 12 is 14,37,430. The total land acquired in this case is 1.756 decimal. In light of our discussion, I find that the compensation of acquired land has been prepared without considering the market value of the acquired property as per the provision of Section 26 of the Act 30/2013 and per Section 26 of the Act. The compensation for the land and the petitioner body comes to 25 lakh 2 crore 52 lakh 25 lakh 24,120.
देखिए आपके इसमें अवार्ड नंबर 4 नहीं है, आपने एग्जिबिट ही नहीं किया अवार्ड नंबर। राइट टू इंफॉर्मेशन में कोई डॉक्यूमेंट ले आए कैसे हो? वेयर इज अवार्ड नंबर 4? वेयर इज अवार्ड नंबर 4? क्या उपाय है आपके पास? प्रॉपर कॉम्पनसेशन चाहिए ना।
Yes.
कैसे आप लेके आएंगे इसको बताइए। फर्स्ट अपील में कुछ अगर अवार्ड हुआ है उसको कैसे लेके आते हैं? यू हैव नो आइडिया, नो आइडिया। राइट टू इंफॉर्मेशन के बेसिस पे कुछ हो सकता है क्या? हाउ इज इट पॉसिबल? आप मिस्टर चौधरी को बुला के लेके आइए, ठीक है? अवार्ड नंबर 4 कहाँ है? आप तो यूनियन ऑफ इंडिया है, कौन है आप? स्टेट। सबको बराबर देंगे कि ऐसे कुछ भी देंगे? अवार्ड नंबर 4 कहाँ है? या उनको एडिशनल एविडेंस फाइल करना पड़ेगा? अवार्ड नंबर 4 तो आपका डॉक्यूमेंट है ना, तो फिर किसी को कुछ भी देंगे। इट्स जस्ट अराइजिंग आउट ऑफ द सेम एक्विजिशन। अवार्ड नंबर 4 उनका तो हम क्या ही करें। अगला डेट में यही कहानी करेंगे जब हमको एक सप्लीमेंट्री एफिडेविट फाइल करना है। ऐसे नहीं कर सकते हैं। They have a right to get adequate compensation. You just can't do this. बुला के उनको लेके आइए, उन्हीं से बात करें, ठीक है? कहीं और हैं बहुत दूसरे को, उनको एक बार बुला के लीजिए, ठीक है? जब same authority कोई award pass करे, he is passing different awards. He will not look into award number, and he has to only see the right to information document. Same authority passing different awards. If somebody is referring to award number 4, you will not see that. Okay, then. What the learned counsel appearing on behalf of the parties. The memo of appeal reveals that the claimant is seeking enhancement of compensation. And the matter arises out of award number 7, arising out of land acquisition case number 24 of 2020, dash land reference case number 37 of 2017-18. अवार्ड नंबर 4 के बारे में आपने इतना
4 को
बोला
नॉट चैलेंज है, 13 खाली चैलेंज,
इसमें तो 13 नहीं है ना,
13 दोनों एक ही साथ,
इसमें तो सिर्फ
4
अवार्ड नंबर 7 है.
7 नहीं, 4 and 13, 7 तो नहीं.
अब जरा देखिए आपने कौन सा अवार्ड नंबर 7 लगाया हुआ है इसमें. अवार्ड नंबर 7 जहाँ पर डिग्री क्या लगाना है, डिग्री में दिख रहा है अवार्ड नंबर 7.
पेज 26,
हाँ पेज 26
नीचे कंपल्सरी अवार्ड नंबर 4, अवार्ड नंबर 13,
नीचे कहाँ है?
ये बीच में पार्टी पोजीशन के बाद 4 and 13, 7 तो है ही नहीं इसमें.
और ऊपर देखिए अवार्ड नंबर 7 लिखा टॉप में.
ये हमको लगता है टाइपिंग मिस्टेक है कुछ, दैट इज रॉन्ग इन टाइपिंग, दैट इज हमको लगता है टाइपिंग मिस्टेक है. देयर आर 2 अवार्ड 4 and 7 13.
तो आपका क्या ग्रीवेंस है
Primarily, the grievance is that so far it is determined, it has been decided by the tribunal that it is a commercial land, and while paying the with regard to compensation with regard to the land, they have award number 4, they have paid with the commercial the current value, and so far the building portion, they have said that since there is no documents what is the value of market value of means commercial value of the land. Therefore, as it is decided by the executive engineer in the while preparing the award 37, उसी को रख दिया गया. That is the finding. Read that question.
Excellent. The learned counsel for the appellant has submitted that the appellant is primarily aggrieved by the fact that, in spite of treating the land on commercial
Yes.
value,
Issue number 1 decided it is a commercial.
by deciding issue number 1,
Yes.
the award number 4 has been prepared accordingly.
Yes.
But while preparing award number 13,
13.
the commercial value of the building has not been taken.
That is only that is the.
The appellant is aggrieved by award number 13 only.
Only, yes, that I have, first para also I have stated, only challenging the award number 13.
You have not filed any document.
Yes. With regard, we have filed documents showing that it is a commercial place or
The learned counsel has submitted that the appellant is only agreed by award number 13
yes,
regarding the valuation of the
Building.
superstructure
yes, super building.
over the land, building over the land.
Yes. It is admitted by the evidence that it is a commercial. It was
वो आप
used.
हमको दिखाएंगे, आपको कब चाहिए?
ये टाइम कम बोल रहा है.
टाइम का आप ले जाओ.
नहीं पहले ये लोग मांग रहे थे इसलिए
दोनों जने मिलकर टाइम लेने का एकदम कहा.
नहीं नहीं तब ठीक है. इसको एक डेट एक सुटेबल खाली मंडे और फ्राइडे को छोड़ दो. रेलवे के लिए
हाँ तो आप भी सुन लिए ना इनका कहानी, ठीक है? वो जजमेंट लेके आइएगा that the onus is on the plaintiff to prove that, but at the same time the onus is also on the railways to give material for the purposes of valuation. दोनों का onus है. अभी एक जजमेंट में आप है ना, बताइएगा इनको कौन सा. अभी ऑर्डर तो नहीं अपलोड हुआ होगा. अपलोड नहीं हुआ.
Get that number I know.
और उनसे मांगिए, वो द मास्टर है इसमें. Was this case for further hearing at the request of the learned counsel for the parties on Tuesday, 2:15?
Yes.
नहीं 10:30 बजे.
10 बजे सवेरे थोड़ा सा
10:30 बजे सवेरे नहीं होता, दोपहर हो जाता.
10:30 बजे कोर्ट को सवेरे थोड़ा सा इधर होता. 2:15 बजे रखते हैं.
2:15 बजे कुछ और भी मैटर्स रखते हैं.
ठीक. अगर 10:30 बजे अगर फिक्स है, अगर कोई टाइम थोड़ा देर के लिए पासवर्ड प्रेयर
हाँ
करें.
जरूरत होगा तो हम कर देंगे.
Yes, that only I am saying.
लेकिन 10:30 बजे
Yes, कोई दिक्कत
है ना, मतलब ऐसे जनरली कोई टाइम नहीं.
नहीं. Yes, my limited is there. That issue
in
number
the
1.
supplementary causes.
Yes, issue number 1 has already been decided in my favor. Taking into issue number 1, issue number 3 it should be decided.
अगर मान लीजिए लैंड कमर्शियल है तो बिल्डिंग का कमर्शियल वैल्यू
Yes.
कैसे डिसाइड होगा?
हाँ, ये बिल्डिंग का ये एडमिटेड है कि वहाँ पर एग्जिबिट है डॉक्यूमेंट्स दैट द इलेक्ट्रिक कनेक्शन वाज कमर्शियल कनेक्शन.
नहीं तो बिल्डिंग का कमर्शियल और जनरल वैल्यू अलग अलग होता है.
कमर्शियल और
कहाँ से बता रहे हैं?
ये
मतलब अगर मान लीजिए कमर्शियल लैंड पर
लैंड का जो मार्केट वैल्यू है
मार्केट के अंदर
Yes.
अगर मान लीजिए कोई एक बिल्डिंग खड़ी हो तो उस बिल्डिंग का लैंड का तो वैल्यू होगा कमर्शियल,
Land, हाँ.
देयर इज नो डाउट, लेकिन उस बिल्डिंग का कमर्शियल रेट होगा ये तो हमको नहीं समझ आ रहा.
लेट मी वेरीफाई ऑन दैट पॉइंट आल्सो. I had asked
क्योंकि
that
बिल्डिंग का कंस्ट्रक्शन और वैल्यूएशन वो रेजिडेंशियल एरिया में हो चाहे कहीं भी हो, इससे क्या फर्क पड़ता है?
yes the rate chart. Yes, the rate chart of the state government, if they can provide me with
नहीं,
that.
they will not provide. They are not here to assist you.
The rate chart I was asking from my yes, that I will try.
नहीं टाइम.
ठीक.
For admission, item 13, first appeal 25 of 2024.
एडमिशन के लिए है. Admit, call for records from the concerned court. Let notice be issued upon the respondents for the requisite under ordinary process be filed within a period of 15 days from today. Appellant accept. Close this case on 10th of July, awaiting service. Let this order be communicated to the concerned court through fax.
For hearing and order 41/11, item 14, second appeal 674 of 2016.
What time? You are there? बताइए क्या है आपका सब्सटेंशियल क्वेश्चन ऑफ लॉ?
The substantial question of law one is if the property has already transferred to lady, which became his estate, can be subject to partition.
Partition was after her death.
What happened earlier in the year?
Who transferred it?
The rightful owner in possession has transferred the
Family
property.
member.
Yes,
Okay.
and it was transferred. Thereafter, a suit for partition was decreed long back. Later on in the year 1996, 197, one title suit was filed, in which it is said that only 1/4 share the vendor of this lady was entitled to transfer. When in earlier proceeding it was decided that the persons who were in possession of the property
अब ऐसे नहीं आप appellate court का judgment पढ़िए. Concurrent finding है ना appellate court से पढ़िए. Point of determination पढ़िए. पढ़िए क्या है आप पढ़ना चाह रहे हैं? पैरा 16 पढ़िए, यही तो आप पढ़ना चाह रहे हैं.
para 14.
16.
Para 14, all the 3 points are being taken up together for sake of convenience, and as they are interlinked to each other in the present case, it is admitted that there was partition among the ancestor of the plaintiff and defendant number 1 to 7 by partition suit number 5 of 1973 from the court of subject Dhanbad. It is also admitted that during the pendency of the said partition suit, parties jointly filed an application to refer the matter to arbitration of 11 arbitrators. The matter was referred by the court to the arbitrator. During arbitration proceeding, parties jointly filed petition dated 2/6/1974 Exhibit 3 that all the joint property will be equally divided in 4 parts. The land sold by any of the co-sharer will fall in his share. It was there. So the property which was sold.
आगे पढ़िए ना.
Further case of the plaintiff is that despite this petition before the arbitrator partitioned the land pertaining to Khata number 21, plot number 2386, area 33 decimal equally among all 4 co-sharers, which is in violation of the agreed term of partition among the parties by Exhibit 3. It is the case of the plaintiff that Mansoor Mahato, father of the plaintiff, had sold 24 decimals out of 33 decimals in the said plot number 23862 Sanjua Mahatain by Exhibit 1. Since the suit property was sold to Sanjua Mahatain by one of the co-sharer, Mansoor Mahato, in the year 1970, prior to partition, the said sold land was not the subject matter of partition, and this part of the land was to be allotted to the share of Mansoor Mahato. Sanjua Mahatain, by virtue of said sale deed, Exhibit 1, became the title holder of the said land and it became her estate. It was therefore prayed that the right title interest of the plaintiff be declared over the said land, suit land. The counsel for the appellant has relied upon a decision of Marappa versus Lugappa, reported in 2011 9 Supreme Court cases 451, and submitted that Hindu woman has full ownership over any property that she has acquired on her own as street. such property shall not become part of the joint family property, and she may dispose of the same as per her wish. It was therefore argued by the land council for the appellant that the suit land sold to Sanjeeva Matain was not subject to partition, and she has acquired right title over the suit property that the court below has erred in not declaring right title in the interest of the plaintiff over the suit. On the other hand, land council of the respondents argued that the fact of the case is not applicable in the present case. In that case, it is. In that case, as it is noticed in para 19 and 20, that a piece of land was gifted to a woman, Bhatia, by registered gift, and thus she became the owner of the said land, and she continued to be in possession thereof. But
इसमें क्या है आपका एग्जिबिट 3 तो आपके ऊपर बाइंडिंग
yes,
आप खत्म है
yes, it is binding upon me. Exhibit 3, by Exhibit 3 it was sold.
no exhibit 3 is not sold. You say arbitrator partitioned the land pertaining to khata number 21 plot number 2386 area 33 decimal equally amongst all the co-sharers, which is in violation of agreed terms of partition. तो जब आर्बिट्रेटर ने इक्वली पार्टीशन कर दिया तो बात खत्म हो गया ना. एग्जिबिट 3 क्या है? अब उसने जो कर लिया सो कर लिया, उसके अलावा तो कुछ नहीं हो सकता.
In the present case, transferor Mansoor Mahato and his beauty had 1/4 share in the joint property. It is treaty law that a transferee of a co-owner cannot take possession of his or her purchase undivided share unless she get his her purchase portion partition in view of section 44 of the PA. The plea of the appellant that the land transferred in favor of Sanjeeva Matain became her history and is wholly unsustainable in fact and law. Mansoor Mahato, while pursuing the partition matter before the court as well as before arbitrator, had never disclosed the transfer made by him in favor of his wife. As such, the court or arbitrator had no occasion to decide the same issue. And the counsel further argued that the present case there stands a decree passed in the suit in which Mansoor Mahato, father of the appellant plaintiff, were a party, so the present suit no relief or title can be granted in favor of the plaintiff unless the decree that stands as insurmountable obstacle avoidable by seeking a relief that the decree passed in earlier suit is filed. And counsel has relied on decision of certain reported in 1996 7 Supreme Court cases. In this case, Honorable Apex Court has held that when a party seeks to establish its title to the property which cannot be established without avoiding the decree or an instrument that stands as an insurmountable obstacle in such a way which otherwise binds him, though not a party, the plaintiff necessarily has to seek a declaration and have that decree, instrument or contract cancelled or set aside or resigned. In the present case, the allotment chart, which was part of the award of the arbitrator, was accepted by the court of subject and by the partition suit number 5 of 73 without any objection. Vendor of Exhibit 1 was defendant in that case, and therefore that decree is binding to Mansoor Mahato. And counsel further submitted that co-sharer has right to transfer his undivided share, but the vendor cannot get possession without physical partition and undivided landed property in case of such and such the Honorable Apex Court in para 15 of the said decision has held without being any physical formal partition of undivided landed property, a possessor cannot put a pending in possession, although such a possessor may have right to transfer his undivided share. In the present case, also the plea of the appellant plaintiff is that he is not sustainable that after execution of said deed, Exhibit 1, Sarua Maidan came in possession of the same. Partition was effected by a ward of the arbitrator and accepted by the court of government of Judge Diwan in partition suit number 5 of 1973. In that partition suit, the land transferred.
When did this lady Sajua Mehtain die? It is her property.
Yes,
When did she die?
she died after the
Yes. If it was her property, she would have come forward to claim that property, isn't it? She is not the plaintiff.
so she died before filing of the suit.
From where do we get this?
That I will give.
From where do we get this? When did she die?
The case of the plaintiff is that it was
आप वो जो मेरी बात भाई जिसका प्रॉपर्टी है वो खुद क्लेम करेगा ना आकर माँ है ना प्लेंटिफ की
जी।
वो हाँ बताइए कब डेथ हुआ उनका Tell us when did she die? And what is the what is the date of sale deed executed in favor of Sajua Mehtain?
in the year 1970 before that partition suit of 73. Thereafter the property was located in her name and thereafter when she died the defendant started making trouble. Therefore in the year 1997 title suit was filed. In the plaintiff it is stated that Sajua Mehtain died and the plaintiff succeeded the property. So before filing of the present suit, she was
Second appeal number 674 of 2016. The learned counsel for the appellant has submitted that though there are concurrent findings recorded by both the courts, but still a substantial question of law is involved in the present case. He submits that the joint family property was subject matter of partition suit number 5 of 1973. And prior to institution of the partition suit, a portion of the joint family property was already transferred in the name of the mother of the plaintiffs, namely Sajua Mehtain, by sale deed number 21295 dated 7/8/1970. And the same acquired the status of Stridhan and could not be subject matter of partition. He submits that after her death, the plaintiffs, being her son, claimed inheritance over the property, and consequently the suit was filed. The learned counsel for the appellant has submitted that the property covered by the sale deed of the year 1970 neither could have been subject matter of partition suit nor could have been subject matter of partition. Upon
Responded.
However, the fact remains that the decree passed in the partition suit attained finality. आप पार्टीशन सूट में पार्टी थे? क्या नाम है आपका? But the same was not challenged by the appellant or by the son of Sajua Mehtain, who was the wife of Mansu Mehto, correct?
Yes.
Who was party in the partition suit. Number 5 of 1973. This court finds that the learned first appellate court has recorded a clear finding that no relief could be granted to the plaintiff unless the decree was set aside. After having gone through the बस हो गया बात खत्म. डिग्री तो आपने चैलेंज नहीं किया.
हम नहीं चैलेंज करेंगे तो
मत करिए. बस इतना काफी है.
ट्रायल कोर्ट के जजमेंट से दिखा देते हैं.
कुछ नहीं देखना है. कुछ देखना ही नहीं.
Award is not there in the record.
We are not. We do not know. Which award is not there in the record? It's an admitted fact that it was subject matter of partition अभी आप ही बहस किए हैं।
It is admitted fact that was not subject matter of the partition, and it was agreed between the parties that the persons who are in possession or sold the property that may not be partitioned, and no award is there on the record. Neither the plaintiff nor the defendant has brought that
It
award.
was an admitted fact. अवार्ड नहीं भी है तो क्या होगा?
Page 39 में.
नहीं ऐसे नहीं, आपको तो सुनने के बाद ऑर्डर कर रहे हैं, आप तो इतना कहानी हमको सुना है,
हाँ.
तो आपको तो रुके नहीं। अभी जो फाइंडिंग है इसका हम क्या करें? आपने डिग्री नहीं चैलेंज
So
किया है।
finding, if that finding is not binding upon me because of the reason that property had already been sold.
अच्छा, एक सेकंड।
So therefore I
एक सेकंड। The
like
learned
to
counsel for
request,
the appellant has also submitted that the finding recorded
therefore
or
I
the
would
decree
like
passed
to,
or the decree passed in partition suit number 5 of 1973 is not binding upon the mother of the appellant and consequently the appellant, and therefore there was no need to challenge the decree passed in the said partition suit.
एक मिनट करना रिक्वेस्ट करना है, पैरा पेज 37 में भी of the brief, पेज 37 पॉइंट है तब तो
कोई पॉइंट नहीं है।
तब बोल रहे हैं, ऐसे नहीं है। पेज 37 of the brief, पैराग्राफ 24, वादी की ओर से प्रदर्श 3 दाखिल किया गया, जिसके अवलोकन से दर्शाता है कि पैतृक संपत्ति का बंटवारा 4 भागों में होना है और विक्रय किया गया संपत्ति उसी पक्ष के अंश में जाएगा जिसने उसे विक्रय किया है।
तो बताइए, तो आपके मतलब आपके पिताजी के अंश में चला जाएगा ना?
हाँ, उनके अंश में जाएगा, वो तो बेच दिए
हैं तो उन्हीं के अंश से न माना जाएगा।
हाँ,
फिर क्या?
तो ये प्रॉपर्टी कैसे पार्टीशन होगा? छोड़ के ये प्रॉपर्टी को
छोड़ के नहीं पार्टीशन,
उनको
जो हस्बैंड ने, एक सेकेंड,
जी।
इतना नहीं होता है फैमिली में, जो हस्बैंड ने अपनी प्रॉपर्टी वाइफ के नाम से ट्रांसफर कर दी, जब पार्टीशन होगा तो वो वाला प्रॉपर्टी हस्बैंड के नाम से आ जाएगा। वाइफ का कोई इंडिपेंडेंट टाइटल तो नहीं है,
तो आ जाएगा। तो 24 डिस्प्यूट को तो छोड़ के ना पार्टीशन होगा।
कैसे छोड़ के होगा पार्टीशन? नहीं होगा।
हस्बैंड के जितना शेयर है उससे 24 डिस्प्यूट जो बेच चुका है हस्बैंड, उसको छोड़ के
उसको
पार्टीशन
छोड़ के नहीं
उसको
होगा।
एडजस्ट करेंगे
पूरे-
दूसरे में।
नहीं, पूरा का पूरा प्रॉपर्टी का इक्वल पार्टीशन
हाँ,
होगा
ये
और
तो-
वो जो बेच दिए हैं वो उनके हस्बैंड के शेयर से एडजस्ट हो जाएगा।
जी, तो इसमें
तो वही किया है।
यही एग्री हुआ था कि जो बेच चुके हैं वो उन्हीं के अंश में रहेगा।
नहीं,
थोड़ा सा हम क्लियर
नहीं,
करेंगे, थोड़ा सा क्लियर करेंगे।
नहीं, आपका कोई केस ही
नहीं नहीं, हम थोड़ा सा क्लियर करेंगे।
क्या इसमें
ये-
क्लियर करेंगे आप?
5 मिनट समय दिया।
हम लोग नहीं उठे, सारा ह्यूमन राइट आप ही के लिए बना हुआ है,
नहीं,
सारा ह्यूमन राइट आप लोग के लिए बना हुआ, हम लोग का तो कोई ह्यूमन राइट होता नहीं है।
आफ्टर
You are absolutely unmindful of the fact that it is already 150. इससे आपको कोई मतलब ही नहीं है।
नहीं, ऐसा नहीं है। हाँ, तो हम चाह रहे थे कि आफ्टर रिसेस ही हो।
पंकज जी आप आ जाइए।
आफ्टर रिसेस
ठीक है, बाकी डिक्टेशन आफ्टर रिसेस। 5 मिनट से ज़्यादा आपको समय नहीं देंगे क्योंकि हम अपना माइंड ऑलरेडी डिस्पोज कर चुके हैं। आपको जो जो पढ़ना है बस 5 मिनट में